Thank you very much for coming. We warmly welcome you to the first edition of the Dignity Law Conference, hosted by the Indian Journal of Constitutional Law in collaboration with the Center for Constitutional Law, Policy and Good Governance and the Access to Justice for Prisoners project.
So to tell you guys a little about IJCL, which is the Indian Journal of Constitutional Law, we have an 18-year-old rich history, and we have continued to be one of the most prominent constitutional law journals across these 18 years. We have regularly been cited by the Supreme Court and other high courts, and also contributed greatly to scholarship both in India and worldwide.
We are hoping that through the paper presentations that are happening as a part of this conference, IJCL is able to take this chapter of dignity forward through a special dedicated issue to dignity law in its upcoming volumes.
Professor Daly's efforts in hosting the Dignity Law Summit at the Delaware Law School is something that has greatly inspired us, and having the chance to read her work in Professor Vasanti's classes was truly exciting. So we are really, really honored to have her here today. Welcome, ma'am.
Without further ado, we invite our Honorable Vice Chancellor, Sri Krishna Dev Rao, to kickstart the conference with his welcoming remarks.
Erin Daly, Maya Daruwala. I worked with Maya for many years. She has been instrumental in mainstreaming access to justice in India. Thanks for Maya for joining this. Vijay Raghavan, who has been, again, another scholar, practitioner, and working with Prayas and TIS, Mumbai, in seeing that humane criminal justice system should evolve. That's a basic theme which we were discussing today. Preetham and all my friends and my dear students. Delighted to welcome Professor Erin Daly of Delaware Law School to India and NALSAR campus. Thanks, Erin, for joining. And Professor Erin brings global perspective and how dignity law is transforming the world. She is invited to India as a global initiative academic network. There's a Gyan scheme where the government of India invites scholars, teachers from all over the world to come and offer the courses. And we wanted to take the benefit of our presence as a Gyan scholar. And that's where the Dignity Conference of today and tomorrow is being planned. I appreciate and congratulate my colleague, Professor Vasanti, and her team for organizing this national conference on dignity, law, the promise and practice by the Center for Constitutional Law, Policy and Good Governance, Access to Justice for Prisoners Project, and the Indian Journal of Constitutional Law. Delighted to see that the conference explores dignity promises and practices across courtroom and community. It brings together the legal fraternity, lawyers, judges, legal academics, clinical educators, and civil society. I think that's the legal fraternity that has to transform the dignity law from the promise to practice. Let me briefly share 3 ideas and thoughts on human dignity. Firstly, the core idea and value of human dignity. Secondly, how the Indian judiciary attempted to develop this dignity concept and idea over the past 75 years. And lastly, the need for developing this transformatory human rights jurisprudence in classrooms and outside the classrooms and court halls. Let me begin firstly with human dignity as the core idea and value. Human dignity has a distinct epistemic, political, and intellectual history. It is the foundation of constitutional law and human rights. It's a pivotal right deeply rooted in any notion of justice, fairness, and society based on basic human rights and human needs. It's a core value in modern democracy and is a central feature in several constitutional states. The Universal Declaration of Human Rights, UDHR 1948, was the first document that included the term dignity in Article 1 of the UDHR. Since then, the concept of dignity assumed central place in human rights jurisprudence. The core values of human rights lie in the recognition and acknowledgement of dignity of a person. The European Court of Human Rights, in its interpretation of Article 3 of European Commission of Human Rights, ECHR, on prohibition of torture, relies extensively on the concept of human dignity, that we could see how the Indian Supreme Court also borrowed in later years. The extraordinary position of right to human dignity in the human rights language and practice is memorably pointed by an eminent jurist, former president of Supreme Court of Israel, Aaron Barak, as the humanity of the human being and centrality in human rights jurisprudence. The debates of human dignity range from constitutional theory to criminal law, free speech to bioethics and several other debates. The courts have used different conceptions of dignity all over the world. Now let me explain the three concepts of human dignity very briefly. The first concept of dignity denotes the intrinsic of inherent dignity. It's the most accepted notion of dignity that focuses on the inherent worth of each individual. When we study the legal theory or jurisprudence, we begin with the natural law and natural rights theory. This is intrinsic or inherent dignity owes its origin to natural law and natural rights theory. Such dignity exists merely by virtue of a person, humanity, and does not depend on any external features such as social status, caste, class, gender, education, or rural and urban divide. The Indian Supreme Court recognized dignity as an intrinsic and inherent right available to citizens in the criminal justice system. The post-emergency Indian Supreme Court provided several safeguards to guarantee the core rights like life, liberty, dignity, and equality through the processes of what we call as a constitutionalization of criminal procedure. The right against self-incrimination, right against torture, intended to preserve the dignity, privacy, integrity, and personal autonomy of every citizen. In the famous D.K. Basu case, the Supreme Court of India in 1997 observed that custodial torture is a naked violation of human dignity. It destroys self-esteem of the victim and does not even spare his personality. Second concept of human dignity is the positive or substantive dignity. The second concept of dignity relies on the social condition of well-being. It can express and serve as the grounds for enforcing various substantive values. The positive or substantive concept of dignity is also associated with social welfare rights or protection by the state from poverty and violence. In this understanding of the human dignity as a positive and substantive dignity, it demands the government to provide the basic conditions of well-being. It embodies what constitutes the good and decent life for the people. The directive principles of state policies enshrined in Part 4 of the Indian Constitution puts the duty on the states to guarantee the social economic rights and fulfill the basic needs of the people. Indian Supreme Court in several of his landmark judgments, starting from Francis Corelli-Moulin, Olga Tellis, a pioneering case of substantive dignity, they have interpreted by ensuring the right to social economic rights, right to shelter as a fundamental right, by indirectly linking it with right to livelihood and elevating to the level of positive duty by the state. Thirdly, dignity is a recognition and respect. The third form of dignity attributes to respect and recognition. The constitutional courts often associate dignity with recognition and respect. This is rooted in a conception of the self as constituted by the broader community. A person's identity and worth depends on its relationship to society. Dignity as a recognition reflects a new political demand, not for freedom or liberty or a minimum standard of living, but rather as a respect, sometimes referred as a third generation solidarity rights. Such rights are protected by the modern human rights documents and some national constitutions. These three concepts of dignity reflect different ways of thinking about what constitutes dignity. Sometimes the boundaries may overlap. Lastly, as someone who has been involved in the legal aid and human rights movement in India over 3 decades, the challenge before all of us is how to develop coherent pro-human dignity jurisprudence in India, both in classrooms using clinical pedagogy and courtrooms through several engagements inside and outside the court. The dignity of the individual finds a specific mention in the preamble to the Constitution of India. In Prem Shankar Shukla, Justice Krishna Iyer long ago discussed about this. The Indian Supreme Court interpreted in Karak Singh, Menaka Gandhi, D.K. Basu, Navtej Johar to Puttaswamy, interpreted the human dignity as part of constitutional culture. It remains in judicial interpretation through case by case. Anup has argued this in one of his articles in the Constitution book of the Oxford. So what is required? It should not remain as a case-by-case interpretation by the courts. There is a need for development of normative framework to protect and promote human dignity. The core values of human rights lie in the recognition and acknowledgement of the dignity of a person. The norms behind the protection of core rights are of a particular strong character, and we all know it's always in a continuous confrontation with the power of the states. Thank you.
Thank you, sir. I think your remarks very adequately captured the theme of this conference, promise and practice. And the overview of the Supreme Court decisions was also quite useful to kickstart this conference. If we may now invite Professor Daly for the keynote.
Thank you so much. It's hard to find the words to express how honored I am to be here and just how excited I am, because at heart, I'm a real constitutional law nerd, but so excited to have 2 days to spend just thinking about these issues and hearing from everybody and learning so much about the opportunity to learn so much about Indian constitutional law and your own perspectives on these issues. So I'm just thrilled to be here. Thank you so much, Professor Vasanthi, for inviting me, for having this idea. We met sort of by accident in a way, and that's just turned out to be just a wonderful friendship and professional collaboration. I'm excited for the week ahead and also to see what comes afterwards. And thank you very much to the organizing team. The students here have been fantastic, very helpful, very welcoming, and just very supportive. So thank you so much. It's a real pleasure to be here. You'll hear, just from what you've heard so far, and I'm guessing the rest of the conference, quite a bit of overlap in what we're talking about and how we're sort of conceptualizing and thinking about the place of dignity in constitutional law, particularly in India, but also elsewhere. I want to start where you did, actually, with the Universal Declaration of Human Rights. Dignity appeared in a few constitutions before World War II, very sporadically, in Mexico, in Finland, a few other places. But there wasn't what you would call sort of a body of dignity law at that point. And where dignity really entered into our consciousness as a legal concept was in the aftermath of World War II, of course, first with the establishment of the United Nations. The Charter of the United Nations identifies several goals for the UN. The first is to end the scourge of war, and the second is to reaffirm faith in human dignity. So those two things were intimately connected. And then the Human Rights Commission, in developing the Universal Declaration of Human Rights, took that idea of dignity and sort of made it a centerpiece of the new sort of legal world order. And if you don't mind, I would like to just read to you, and you mentioned some of this, but I would like to read to you the opening language of the Universal Declaration of Human Rights. So just bear with me. And I know you know all this, but I think it's worth understanding just how important and impactful this language has been, and also, frankly, how radical it has been. So I'm just going to read a couple of passages from the preamble, and then, of course, the famous Article 1. The very opening words of the Universal Declaration of Human Rights is, whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. A few paragraphs down. Whereas the peoples of the United Nations have in the Charter reaffirmed their faith in fundamental human rights, in the dignity and worth of the human person, and in the equal rights of men and women, and have determined to promote social progress and better standards of life in larger freedom, so invoking the UN Charter and sort of bringing that language forward. Now, therefore, the General Assembly proclaims this Universal Declaration of Human Rights as a common standard of achievement for all peoples and all nations. And then begin the 30 articles that enumerate the Universal Bill of the Universal Rights, beginning, of course, with Article 1, which I will also read. All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Now, again, I pause on this language because I think it is really extraordinary language, particularly if you think of it in its historical context. What the drafters of the UDHR were charged with doing was not just creating a Bill of Rights, like so many constitutional drafters have done, but really charting a new path. This is in the immediate aftermath. The embers are not even cold yet from World War II, right? And here they are, these men and women who've gathered from around the world to say, that was a really terrible thing we just went through. We keep doing this twice in our lifetimes. And we need to set a course for changing direction of humanity. Right? It's a pretty tall order, right? And the idea that what they did was to accomplish that goal of changing the course of humanity was to say, let's start with the principle of human dignity. And human dignity is not just a good idea or some good feeling, that we all like our dignity, but it's the foundation of peace and justice and freedom in the world. I imagine this little idea of dignity, this little word of dignity, with this huge, unbelievably heavy burden on its shoulders, being the foundation of peace and justice and freedom in the world. And it's all sort of based on the shoulders of human dignity. So the idea of dignity, the work that dignity is doing in this document is as a pivot, essentially. Never before had the nations of the world come together to really try to change the course of human events, to lead us away from the habit of war and towards this garden where the dignity and worth of the human person could flourish, and where men and women live with equal rights in social progress and with ever better standards of living, standards of life and larger freedom. So this is a monumental moment, and it's focused squarely, sort of laser focused on the idea of human dignity. And what they say about dignity is, I think, really important, and also, as I mentioned, extremely radical. First, and you mentioned this also, dignity had been, for the most part, thought of course, as rank or status, right? Very important people have dignity, kings have dignity, nobles have dignity, but regular people don't. Well, that changed with the UDHR, right? And I don't believe that dignity, that idea of dignity was abandoned. I think what was recognized in the UDHR was that all of us, everybody, every single member of the human family in present and future generations has that same worth that was once reserved to kings and nobles, right? So it's not that we abandon the idea of dignity as worth. We just recognize it in every human being, and it's innate, in meaning, as a legal matter, meaning that it isn't given. It can't be taken away. It's just part of who you are, every member of the human family. And that's also an important concept in the sense that it makes it actually resistant to law. Law can diminish your status, but it can't take away your dignity if it's innate. It's a part of the human personality. Another thing that's radical about the UDHR is that the U in UDHR, the rights here are universal. Every person. Now, again, put yourself back in the mindset of 1945, 46, 47, a momentous time in Indian history, a momentous time in world history, and a time where that very question about, well, is everybody really, does everybody have dignity? Is everybody important? Was front and center, right? This is exactly what everyone was thinking about in the world. And the UDHR comes down squarely on the side of universal dignity, right? Emphatically and without any reservation on the side of universal human dignity. Tied to that, but it's a separate and separately important point. Dignity is equal in everyone. You might have said, well, everybody has some dignity, but people have different amounts of dignity. But no, the drafters of the Universal Declaration of Human Rights said, first of all, everybody has it innately, and everybody has it in equal measure. That is just extraordinary for that time, and frankly, still extraordinary for now, to make such a strong commitment to the equal worth. And I know you know all this. I know you've been studying this and you've thought about this. But I still think it's just one of those things that I think is so so dramatic, really, that it's worth just pausing and remembering how important it is and how high a standard it holds humanity to. One piece of this question about equal dignity, there's a lot that can be said about it. People write books about it, etc. But one little piece that I just want to draw to your attention is that if everybody has innate dignity, so not given, but innate, and everybody's dignity is equal, that withdraws from all of us the power to judge another person's dignity. Now, if you think about, again, if you put yourself in the mindset of the people who were drafting this in 1948, they had just endured, and the world had just endured, unimaginable savagery, really, right? Unimaginable but real savagery. And savagery all over the world in all kinds of different places, but certainly the Holocaust was front and center in their minds. In the Holocaust in Germany was front and center in their minds. And if you think about what the justification for something like the Holocaust is, it comes down to, in a sense, and I don't mean to simplify something that's very complicated, but it comes down to, in a sense, the idea that one person can say, you're not worth as much as I am. Your life isn't worth as much as I am, and therefore I get to make all kinds of decisions about what I'm going to do with your life because it's not worth as much. And again, that whole idea was withdrawn the moment the UDHR commits to a system, a human rights system that's based on the idea of equal and inherent dignity. Another thing that the UDHR does that I think is very dramatic is it connects the idea of dignity to the idea of rights. So all of this that we've been talking about was not drafted in some philosophical tract, right? This wasn't just, what is humanity? Oh, it's about human dignity. This was a universal Bill of Rights, granted non-binding, but nonetheless a universal Declaration of Rights. And in the language that I read, you see several times not just the idea of the inherent dignity, but of the equal and inalienable rights, the connection, the sort of the marriage between dignity and rights, that they're intimately connected, not the same thing, but intimately connected. And that's important also, because what the drafters of the UDHR were saying then was we need to reaffirm faith in inherent human dignity, but we don't just stop there. It's a legal concept. It's not just a nice idea. It's a concept that has impact, that has legal consequence and legal effect. So what the UDHR does is sort of two things that are twinned. One is it operates descriptively to describe what human beings are, human beings as having this innate and equal inherent dignity. But then it has a normative aspect. And the second part of Article 1, the first part is all human beings are born free and equal in dignity and rights. There's that marriage of rights and sort of the sort of embodiment of all these different concepts I've been talking about. But the second sentence is they are endowed with reason and conscience, okay, and should act towards one another in a spirit of brotherhood. So there's this normative aspect. Because we have dignity, we don't just sit around and say, wow, isn't that cool? We all have equal dignity. It actually should affect how we act towards each other. And this is what makes it relevant in law. I once read a book that I found enormously sort of insightful, and it was called Law's Relations. And the idea of the book was really to say that what law is describing relationships, people to people, people to things, people to concepts. But if you think about law, not as sort of this given set of rules, but about just describing relationships. And I sort of thought that idea was interesting. And you see it very explicitly in that second sentence of the first article of the UDHR. All human beings should act towards one another in a spirit of brotherhood or sisterhood, as it were. So there's consequence to this recognition of inherent dignity. Now, I think the aspirations of the UDHR were very high, were very noble. One could argue that they didn't quite work out that well, because it turns out that the scourge of war, well, still with us. So I think it's hard to sort of evaluate the impact of the UDHR, whether it's relevant today. And part of the way you measure relevance is actually not by how much people talk about it, but how much people incorporate it into what they're doing, and then maybe even stop talking about it. And that's what's happened with the UDHR. I mean, it's still discussed a lot, but really the impact of the UDHR, the reason it itself is relevant and that language is relevant is because those ideas that are articulated so briefly and concisely in the preamble and the first article are with us today in so many different ways. So that language, those ideas have spread through human rights law, which is really the body of law that was specifically designed to protect human dignity. That is what human rights law is about, right? And so we see in the international treaties, the international covenants, the various conventions, all of the declarations and treaties of human rights are based sometimes, usually explicitly, but sometimes implicitly, on this notion of human dignity, specifically as it was conceptualized in the UDHR. We also see it in, you mentioned the European Court of and the European Convention of Human Rights, where again, not explicit in the convention, but but has been read into the convention by the European Court of Human Rights as an essential part of the European Convention. We see it in numerous documents in the inter-American human rights system. We see it in the African human rights system. And we also see it now in the constitutions of the world, of course, primarily in India, but also in many, many other constitutions. There are about 194 countries in the United Nations. Somewhere between 160, 170 of them mention dignity in their constitutions. That's extraordinary, right? That's extraordinary. That's almost all of the constitutions in the world that talk about human dignity in one form or another in their constitutions. And the shift from international law to domestic constitutional law, I think, is really important also. And again, you all know this because you're living in it, but I just want to sort of describe to you or highlight how important this shift is. There are some cases, we were just talking about one of them, where the international human rights system issues opinions of one kind or another, right? But they're very few. Law doesn't really happen at the international level. It happens a little bit more at the regional level in some parts of the world, but even there, not that much. Where law really happens is at the domestic constitutional level. And even there are gaps, but still, that's where it happens most. So by shifting this idea of dignity from the international level, from a declaration that's non-binding into these binding treaties of international law, into the constitutions, we see a number of things happening. First of all, these constitutions get interpreted by constitutional courts, of course, right? So that gives the courts an opportunity to take this one word and elucidate and expand and apply it to real situations. So that's the body of law that we have. But again, just trying to draw your attention to the fact that this is a really important phenomenon, that you take this word and then you render it into binding law for the nation. By shifting it from the international level to the domestic constitutional level, another thing happens. Each court takes this one word that has this global significance and makes it their own, right? So dignity in Indian jurisprudence has a certain aspect to it, a certain flavor, if you will, and it's slightly different than the way the Colombian Constitutional Court or the German Constitutional Court or the Israeli Constitutional Court or the South African Constitutional Court, et cetera, understand dignity. So it allows, by shifting it from the international to the domestic constitutional system, it allows each court to say, this is what it means for us here now. And that makes it more real and more relevant and more applicable. And then thirdly, it's binding law. International law has its troubles in terms of enforcement. So does domestic constitutional law, but much less so. It's binding law. So I think that shift from this word in this document to the constitutions of almost all countries is really significant. And it has resulted in this very vast jurisprudence of dignity. I'll make a few comments, just general comments, and I'll speak with a little bit more specificity in the next session. But at this point, I'll just make a few general comments about this global jurisprudence of dignity. First of all, it's geographically very broad. I mentioned in all the regional human rights systems, but also in these constitutional systems, we see dignity cases in every continent, in pretty much every country. And I say pretty much because I'm not sure if there's an exception to this, but I will say at least pretty much in every country where there is an active constitutional court that is engaging in constitutional review, there are dignity cases, even in the US. We see it in every legal tradition. We see it in civil law traditions. We see it in common law traditions. We see it in religious traditions. We see some court in Pakistan says, well, of course we believe in dignity because it's part of Muslim law. We see it in Israel. We see it in India. We see it in all these different constitutional cultures that have different religious or ethical or cultural contexts. And we also see it in secular law. And we see it in the regional courts. So it's geographically vast. It's also substantively vast. And again, you mentioned this a little bit. We see cases on dignity, and again, I'll talk about this in a little bit later, but we see cases on dignity that are really on everything that's of importance to people, from gender and sexual identity to voting rights, to criminal law. Yesterday, I get my time frames confused, but I think it was yesterday, the Inter-American Court of Human Rights issued a milestone, and this is a situation where the word milestone, I think, understates how important this case is, about climate justice, establishing a right to a clean, to a stable climate, to a healthy climate. So a major case about climate justice, referring also to dignity rights in the context of the climate emergency. So we see it on, that's just a few examples. And again, I'll talk about this a little bit more later. Sometimes in these cases, dignity is an explicit right, like in the Constitution of Germany. Sometimes it's implied. It's not actually mentioned in the Canadian Charter of Rights and Freedoms, but the court has implied it. There are a few cases in the US where the court has implied dignity from the confluence of equality and due process law. Sometimes it's sort of constructed, if you will. It's somewhere in the Constitution, and the courts have sort of reframed it. Arguably, this has happened in the Indian constitutional context where it's in the preamble, but then it's turned into something else in Article 21. This happens in France. Sometimes it's sort of pulled out. It's in the Constitution in a very minor way, and courts have said, well, have sort of built a lot into that one word. And sometimes it's not even a right at all, but a value. And sometimes it's more than one of these things. So we see it sort of operating in all these different ways in different cases. In some ways, it's exactly like other rights in the sense that it's a justiciable right. You can walk into court, you can say my dignity rights have been violated, and a court will listen and maybe render a remedy. In a lot of ways, though, dignity rights are very different from other rights. In some ways, dignity rights sort of stand outside, and this is a little bit like the UDHR operates. There's Article 1, so it's just one of 30 articles in there, but somehow Article 1 is really different and separate and meant to sort of presage everything that comes next, right? And so you see the same thing in constitutional law. In some ways, it's just another right, and in other ways, it's viewed as both the source of other rights and also the purpose of other rights. So we interpret this other concept in a particular way because it stands on the idea of dignity as a foundation, or because the purpose of this right should be read in terms of human dignity. Yes, please, please. In a lot of countries' jurisprudence, dignity is absolute, and that makes it quite different from other rights. It's absolute in the sense that it's not subject to balancing. It's not subject to allowing the government to explain its justification or to justify its violation of dignity. You don't get cases where the court says, this is torture and it constitutes a violation of dignity. Now, government, what were your good reasons for engaging in it? Once you find a violation of dignity, the case ends. Because there's no justification. And related to that, but it's a slightly different point, dignity is inviolable. The state must find some way to accomplish its legitimate goals other than violating dignity. And that applies to everything from dignity-based torture and mistreatment to dignity-based discriminations or anything else, or violations of privacy or anything else. So, and then lastly, you see dignity as a right, but you also see it sometimes as a remedy, as the basis for a remedy. So the court might say that you have to, that the state has to establish a level for pensions, this is from a German case, that complies with human dignity. The courts won't say what that level of pensions is, but it'll say whatever it is, it must comport with human dignity. You see this in cases involving trash pickers and others, where the dignity violations are sort of so complex and interwoven that the remedy also has to address a whole panoply of dignity rights. And sometimes you see it sort of baked into the remedies. What's astonishing to me about these cases is, despite their great diversity, there's a great harmony among all these cases, what you might call an overlapping consensus, right? There's no definition, they're not exactly the same, but there's a great overlapping consensus of cases. In other words, there is this is a phrase, I don't know if this translates here, but there is a there, right? There is something there to dignity. One of my con law professors used to use that phrase all the time. Some people criticize dignity as being too elastic, too amorphous. Ronald Dworkin used the word flabby from overuse. And it's true that dignity does have broad contours, but it does have contours. Dignity isn't everything. There are things that are dignity violations and dignity rights, and there are things that are not. So it does have contours. What's interesting about these cases is that in so many of them, the vast majority of cases, the courts don't need to rely on dignity to decide the way they want to decide. Almost always, there is another more specific provision in the Constitution, whether it's privacy or equality or due process or something else in the Constitution, that the court could look to and say this violates that clause of the Constitution. And instead, what courts are doing in these cases is saying, yes, it does, but also it violates human dignity. So it's a judicial choice to talk about dignity, to go and explore what dignity means in the context of these cases. So that gets me wondering why judges are doing this. They could make their lives much simpler and write, frankly, shorter opinions if they didn't sort of digress and talk about dignity. So the question is, why is that digression worth it? Why is it not really a digression? And I want to just posit a few hypotheses about this. Of course, I don't know the answer, or maybe there is no answer to it, but let me just suggest that dignity is doing some things in these cases that other rights cannot do. A few things. One, and again, you sort of alluded to this, but dignity makes a case human-centered. I feel odd saying that because it seems to me that law should always and invariably be human-centered, but apparently it's not. And sometimes courts will talk about efficiency or justice or some other abstract interest that trumps the human interest. And what dignity does in a case is it focuses the issue squarely on the human beings at issue and sort of compels or at least invites the judge to consider the issue from the perspective of those human beings. And often in these cases, those judges have very little life experience that's shared with the human beings who come before them. And what dignity does is it reminds them that we are all of equal dignity. So I need to understand this case as if I were in your shoes. And that's sort of an important thing for judges to do. And if dignity is doing that work of sort of bringing judges along to the other side, then that seems to me a really good thing. I'll give you just one example from this case, this Inter-American Court case. It was an advisory opinion, so technically it's not binding at all, even compared to other international and regional law, it's not binding. But the court in this case was, the case arises out of a request from Colombia and Chile to identify the state's obligations with regard to climate change, right? What are states supposed to do given climate change? And I won't go into detail in the opinion, but I will say that in deciding this case, and it took about 2.5 years from the time the petition was filed to yesterday when the decision was issued, the Inter-American Court held a series of hearings during which it received more than 260 amicus briefs and heard from over 160 delegations. And it held hearings in different parts of the Americas, one in Barbados, one in Brasilia, but also one in Manaus, which is in the center of the Amazon. Very hard to get to unless you happen to be in part of an indigenous community, and then it's very, well, not easy, but it's there. The point is that the court, in making this decision about what were states' obligations with reference to climate change, the court understood that it could not do this job unless it heard from all kinds of people. That's a procedural way of thinking about this issue of dignity being human-centered. The opinion itself sort of reflects that in a lot of ways. Okay, so first, it's human-centered. Secondly, dignity is the guardrails of constitutional democracy, right? The Constitution itself is supposed to be the guardrail of democracy, but dignity is what's doing the work in the Constitution of limiting, frankly, what a majority can do. This is why we don't have pure democracies where a majority of the people can do whatever they want because they're the majority. There are constitutional limits on that, and human dignity is the principal one. So we see this in cases about individual freedom, say in speech or capital punishment or other forms of punishment, where the legislation may reflect what people want, and the court will say, yeah, that's right, but it violates human dignity to treat people like that, and so you can't do it. So it performs this function of being like a guardrail. This is in the US right now, there's among the many controversies, one is about due process and who is entitled to it and whether it's sort of dignity-based in the sense that everybody is entitled to it or whether it's based on something else. Third, dignity is progressive. It's always moving forward. You recall the language from the UDHR about better standards of life and larger freedom, right? It's got this push towards progressivism. I've wondered whether dignity whether embedded within dignity is the concept of non-retrogression, that once you've established a dignity right, you really can't go back, that dignity is always moving forward. Connected to that is that it can be culturally transformative. And again, this goes back to the UDHR. The purpose of the UDHR was to say, oh, we were in this place where we kept having world wars. Let's pivot and move to something different, reject what we've done in the past. And that all that language that I called radical before is really language of transformation. It's saying we can do better, we can do differently. And you see that notion of transformative justice in so many cases involving dignity, where it's used as a lever, often to depart from very well accepted, very well entrenched, often religious commitments that had been accepted for whatever, decades, hundreds of years, millennia. And then a court comes along and says, yeah, I get that. I understand that it's all what you've always done, and yet it violates human dignity, so it can no longer be done. The very first case in which the European Court of Human Rights identified dignity as a value in the European Convention, even though it wasn't explicit, was a 1995 case about marital rape, where a man was prosecuted for marital rape. His defense was, come on, everybody does this. We've always done this. We've always had the right to do this. The court agreed completely with that factual statement and then said, and yet it violates human dignity. Dignity is embedded implicitly, the very essence of the European Convention of Human Rights, so it's no longer acceptable. This is just a very dramatic illustration of that transformative, that pivoting power of dignity. The last thing I want to mention about the work that dignity is doing in these cases is that I think, and this may be obvious, but again, I think it's sort of worth pausing on the mechanisms for how this works. Dignity is extremely empowering, right? It's empowering to people. That's the whole purpose of it. That's the purpose of it in the UDHR. It's the purpose of it in constitutions, and it's the purpose of it in constitutional law. It is meant to expand the capacity of each individual, not only to live a better life and larger standards of freedom, but to engage in a social and cultural and personal and political community, right? To allow each person to be part of a community, to not have people who are literally marginalized on the margins of society, but to bring everybody in to the polity, because every person matters. So in a lot of ways, sometimes explicitly, often implicitly, the courts will use dignity to sort of buttress the notion of citizenship. And I mean that sort of with a lowercase c. I don't mean citizenship in the formal way, but being a citizen, being a member of a community. And in that way, when judges are advancing dignity rights, they're really expanding the democratic space, the space in which democracy happens. They're expanding the number of people who are part of the democratic polity and expanding the activities that those people can engage in to expand the space of democracy. So it's an interesting sort of push and pull if you think about judicial activity or activism on the one hand, and often we see that as limiting democratic space. But in the context of human dignity, where the courts are using the fullness of their powers to expand human dignity, what they're really doing is certainly not arrogating power to themselves, but arrogating power to the people. And we see that with respect to cases about social rights. We see that with respect to cases about education in India as well as elsewhere. We see it with respect to procedural rights. We see it in all of these cases where dignity is being used to empower people. I don't believe that dignity is, as someone once asked me, if it was just turbocharging other rights. In some ways, maybe, but not really. It's often sometimes described as a Swiss Army knife. It's just like the thing you pull out when you don't know what else to use. And yeah, look, there's a tool that can help you with this. And I don't think that's what dignity is either. I think what dignity is in these cases is a tool that gets the very, very hard parts of the job done, where nothing else, no other concept in law can really do that work. It's the tool that you use when you're thinking really hard about how to bring the law closer to justice. And I think it can be very useful in that way. And I'm really excited to hear more as the conference continues. Thank you very much.
Thank you, Professor Daly, for your address, which excellently covers the historical and comparative overview of the concept of dignity. Now, without further ado, I would like to invite Professor Murli Karnam to speak about the Access to Justice for Prisoners project, which represents one element of NALSAR's commitment to the practice of dignity.
Good morning to everybody. Professor Sri Krishna Devarao, Professor Vasanthi, Professor Vijay Raghavan, and Maya Daruwala. Thank you for being here. I was asked to introduce about the Access to Justice program that we have started almost 14 months ago. This was a culmination of running prison legal aid clinic for the past 7-8 years. Under the program, we have a multidisciplinary team, a team of 5 advocates and 4 social workers. So we have access to prison, and also our advocates file the cases. Especially, we are dealing with under trial prisoners, basically focusing on getting relief, especially bails for the people who are at the stage of pre-trial detention. After listening here in Delhi, the most difficult question that I have been facing for a long time is whether the people who are accused of violating the dignity of others, do they have right to dignity? This is the question that we face all the time in the prison, in the court, as if they don't have this inherent equal claim for dignity. At almost there is a consensus in the prisons and in the courts, and certainly the criminal law practice is not human dignity centric, especially in Hyderabad. Because from our experience, I can say it's procedural centric, it's a gravity centric, it is crime centric, anything but human dignity centric. So in the past 14 years, we have reached out to almost 600 prisoners. We visit 3 prisons, and in the prison clinic, we have 12 to 13 students who make at least 8 to 10 prison visits in a semester. In the last semester, students have done excellent work, and they build the data, and on the basis of data, our social workers take up the cases, and they further build the, they contact family members of the prisoners and also their advocates, and where under trial prisoners claim that they absolutely have no other advocate working for them, we take up those cases. We have 5 lawyers who are deeply committed for providing right to liberty, and it's a very strenuous work because we work in almost 7 to 8 courts, and in the past 14 years, in relation to 100 prisoners, we have filed 150 bails, and we could get 95 bails, and around 90 prisoners have been released, including 46 juveniles. And we are doing very simple cases, in the sense there is a lot of resistance from the prison department also, that we can't take up certain kinds of cases, like if they are involved in POCSO, if they are involved in NDPS cases. There is a lot of resistance, even from the judges. I can't venture to say that we could get the relief for the prisoners at an appropriate time, because there is, in most of the cases, prisoners are spending time more than they deserve, in the sense that they may not be threat to the victims of crime, but still, as part of procedural, unwritten code that is in practice in the courts. So courts decide that the people who are accused of certain kinds of crimes cannot be given bails before 40 days, 50 days. We also wait for them. So it is not that we are really confronting courts or police stations on the principle of dignity. We are trying to slowly build our program so that we are looking for acceptance from the criminal justice system, but that's not very easy. So it's a serious struggle, and in the afternoon, when there is a special session on our understanding of our experience of, if not dignity, we are very clear about what are the forms of indignities. There can be a lot of debate about what constitutes dignity, but as far as prisoners are concerned, what constitutes indignity is very clear. That much I can speak in the afternoon, especially in the courts, in their relation with the lawyers, in their relation with the police, in their relation with the prison department. The questions of indignity are very clear. One thing that I can say is the question of dignity, which we can claim to be inherent and exist in equal measure, has not been a reference point at all, especially in the courts, in deciding whether somebody should be freed. We almost struggling to believe that every accused still an innocent unless proved otherwise, because the dominant consensus is that every accused who is in the custody of the prison is almost believed to be an offender. At least the pattern with which the bail jurisprudence is handled by the courts, especially lower level courts, makes us believe that every accused is an offender. even without being proved. That is the status that we are experiencing. And there are a lot of interns who are working with us, and we have started an office in the city. And I look forward to new batch of students to align with our advocates and social workers. And we want to take forward this program in future also. Thank you.
Thank you. Hello. I think many students in this room have had the opportunity to hello. Yes. And it's
Good morning, everyone. A very warm welcome to this conference. I would first, of course, like to thank the Honorable Vice Chancellor for taking time out. We're all in the midst of preparing for our convocation, and it's been really, really, really busy. So I must thank you for taking time out and spending time with us in this conference, which shows that there is a commitment to these values, even from people who are performing administrative roles. But as a person who's always been interested in human rights, it's wonderful to have you with us today. Also, thanks to Professor Daly, with whom we've had this conversation for over a year. This conference has been a result of a conversation that we've had for, we've actually had a conversation without actually meeting for more than a year. So it was really wonderful to meet up in person and find that there are so many things that we have in common in terms of understanding constitutional law, not just as a set of legal texts or a set of legal norms, but something that has always been something very close to my heart, which is how do we bridge the gap between what is the promise of the norm and what is the lived reality of people. And what has really struck me about your work is not to give up hope. I suppose where we are in this point, and it is so poignant that you say that this comes in the aftermath of the Holocaust, and possibly we are living in the aftermath of another Holocaust. And in spite of all of this, and so the idea of the conference also is to say, okay, what is the promise, or what is the hope that one must live with in order to be able to negotiate the difficult situation that we find ourselves in. And I have been really inspired by the work that you have done, which is using dignity not just as a legal concept, not just as a norm, but finding ways of translating that to improve the lives of people around you, to improve the understanding of law and the role that it has to play. I'm also deeply grateful to our distinguished panelists who've taken time out to be with us over these 2 days. And I'm really looking forward to hearing from all of them. They've all been persons who are committed to the question of rights and its realization. And I really look forward to hearing from all of them. I must also place on record the tremendous work that was done by the student volunteers to make this possible. I don't think I've written a single word or put anything into practice. And I'm only given instructions, and it's really been something that students have pulled off. And I really want to place my gratitude to them for having put this together. So just a few thoughts as we move into the tea and we move into the more substantive sessions. And the few thoughts that I had is one, that we've spoken about human dignity as a norm and its translation. And what Professor Karnam has also told us is perhaps what you will see around you is the various ways in which human dignity is violated. So I suppose if you start looking at from the sense of, okay, where is it that we're going to find dignity, then it's very possible that you will find the indignity around you far more obvious than you would find the recognition of dignity. Now, in these circumstances, what is it that we are looking for in this conference, and what is the significance of the conversations that we are trying to have around dignity? If we are going to find that we're going to see that it is in violation, that you're going to see it more than in its practice around you. So for me, the idea of this conversation and the clinic that we're going to do next week, and it's also a clinic that Professor Daly also runs, to make sure that the norm is always matched with outreach or with a definite goal to change something around you. So even if the task before us seems to be enormous, and even it feels that it's virtually impossible for us to be able to get anything done, to remain steadfastly at it, believing that there is a value in it, is what the conversations are about. The fact that an academic institution finds space for looking not just to train lawyers and to look at education and to look at training as a legal professional in an isolated manner, but to be able to give students a sense of where the law is rooted. And I would like to make a connect with two of the other discussions that we've had just as we opened the semester. One was on secularism as fraternity, and the other was on constitutional morality. Both speakers speaking on the Constitution were observing that is there a disconnect, is there a growing disconnect between where we started off in terms of our constitutional rights and values and where we are today, in terms of it becoming a largely technical, legal, analytical exercise, and less of an exercise in terms of how people experience the law. So constitution writing in all countries has always been a moment of, it has been an emancipatory moment, it has been an establishment of norms, it has been a moment of great hope and enthusiasm. So what happens to it over the period of time? And exactly the point of the UDHR as well, that the moment in which the UDHR is written and what happens subsequently, where is it that we kind of lose the way, or we lose the plot, so to say? So the idea of this conversation is also that where have we lost the plot? Where is it that we have stopped thinking of this as so directly related to, as Professor Bakshi puts it, the question of suffering or the question of pain, or as our panelists put it, the question of emotion. So as constitutions are written, they're not written as legal texts meant to appeal to somebody's intellect alone. When constitutions are written, they're written, they all usually speak in the name of we the people, with the idea that the people, and as Professor Daly was putting it, the human is at the center of it. So over a period of time, and why as law universities this becomes an important concept, not that dignity is a purely legal concept, but when dignity enters the legal space, what is its potential to transform that legal space? What is its potential? So as the way in which Professor Daly put it, how does it help the judge to see this as a question of a human suffering? How does it allow us to approach questions not purely in analytical or purely in normative terms, but also to say, how does experience then shape the norm? And can experience shape the norm? Are we able to reformulate dignity as a legal norm based on the experiences of people? And that, I think, is an exercise that a law school is very well suited to. And so this conversation that we have, where we have invited people who have been engaged with the question of justice and access to justice, but also in a space that perhaps is very well suited. So while lawyers are very important in the legal profession, to leave very important questions to the lawyers is also perhaps not sufficient. And as we are entering that space of the justice system as a law institution, it allows us to play a space, it allows us to play a role in it. There is a space there. And the idea of this conference is really to explore what that space can be and how best we can shape that space to make sure that not only are we educating students in a particular way, we are equipping them with a certain set of tools, but we're also making them very conscious of this location of the law in the larger society that they see around them. The most important part of what I was fascinated with this question of human dignity is how it allows us to navigate these different ideas, navigate the idea of different laws, because over a period of time, and even the question of rights, over a period of time, we have seen such an explosion of each individual right. And we have reached a point where we are also arguing that the rights are in conflict with each other. Human dignity somehow allows us to, in that sense, come back to the basic idea of what are these rights meant to be doing and why these rights are to be respected, and how is it that when we talk about a conflict, like the question that Professor Murli was asking, that are people who violate human dignity also entitled to human dignity? Because the traditional framework of the law is that there is a person who is suffering and the other person is a person who's supposed to help that person, right? It rarely engages with this question of what happens when one person is accused of violating dignity and then is making a dignity claim. So it's really that human dignity is asked to perform a very, very difficult task. Perhaps do something that all other rights and all other processes are perhaps not best equipped to do. So these are very hard questions that dignity manages to raise for all of us. And not just in particular contexts. And I'm so glad that Professor Daly is talking about the extension of this to environmental justice or to climate justice. That this cannot be seen, while we started off with the idea of human dignity, and we started off with the idea of human rights, it's no longer something that is confined to the business of just the human race anymore. And when we are saying that yes, there is human dignity, we are also saying that this is the human race that is responsible for creating such devastation around it, which is making life virtually impossible to live, right? So in that context, what is it that dignity brings to the table that allows us to negotiate this world? What are concerns of emotion, concerns of care, and concern of respect and solidarity that dignity can bring in, which perhaps somewhere we have lost the plot when we say that all constitutions possibly enshrine dignity, and yet we find it very, very less respected in societies around us. So what is that distance that we have traveled from that initial period to where we are now? And if it is possible to trace exactly where this has gone, then it perhaps allows us to engage with law in a far more rooted manner, rooted in emotion, rooted in a sense of dignity. Because when we say dignity is the root of all other rights, it is also rooted in a consciousness among all of us. And if that is something in the claim for rights, that we lose this sense of being, then I suppose this is a conversation that allows us to not only look at what is it that the other person is supposed to be doing, but also in terms of a consciousness of your own obligations towards everyone else. And if it is possible to turn the gaze inwards and to look at how much of our conduct and how much of our thinking is in consonance with the idea of dignity, I think that would be a useful start. And this amount of reflection, if we are able to convey even a small amount to students, and then we're able to create an environment, a culture in which possibly the question of dignity can receive more traction. So with this remarks, I will bring the session to a close. Would welcome all of you to join us. If there are any comments that anybody would like to make? I think we still have 5 minutes from any of our panelists or guests. If there's anything that you would like to highlight at this point of time, we could take comments for 5 minutes and then we'll close for tea.
Since you said we have 5 minutes, and just I'm hoping that during the course of the conference, we'll be able to break down some of these things which have been put in opposition, which is experience, emotion on the one side and analyticity on the other side. Because as much as we think that it is experience that constitutions or the EUDHR wanted to bring in, the instrument which was used was the text of the law and to order things in a set way. And I felt that in this panel that actually these are not mutually exclusive. There are ways of thinking about them where analyticity and experience and emotion can be thought of together. And I think that's the challenge that we have before us today in law. So yeah, really very interesting comments in the opening panel, and Professor Daly for raising these very important questions, and looking forward to the rest of these discussions in dissolving some of these distinctions sometimes that we and walls that we build.
Hello, am I audible? Thank you all for all to be here. I'm really excited for this conference. I just, because you opened the, I think, platform for comments. I think Professor Dali, when she went into the climate change part, I think I sort of expected Professor Vasanthi to address that as well, for that how we have been seeing, at least in all the remarks, of dignity as an anthropologist thing, as a human dignity concept. And I think Professor Vasanthi also teased that it's beyond the human race and brought in inquiries of ecocentrism to some extent, and how from human dignity or of seeing the personhood just in human to then moving beyond, and now considering climate change is the greatest challenge of our times, and we are moving into this final generation of rights in general. So how dignity and how it would be explored in different persons and would not be just limited to humans is something I believe Professor Dali opened up, and Professor Vasanthi also teased upon. And I believe the first session also deals with personhood. So it's something that I'm really I'm looking forward to. And I believe that this session just really set up a good platform to explore that as well. So thank you, guys.
If there are no further questions, we can, I think, bring the session to an end. Thank you, everyone, for coming today. And we'll get into the next session at 12 o'clock. Thank you.
All the students who registered, kindly leave from that gate. Batsal will be taking attendance so that we can make your certificates later. So leave from that gate. Everybody who registered. Maybe we can close the door.
Or you can. Okay. Welcome back, everyone, to this session on dignity and constitutional personhood. And I'm sure it will give us an opportunity to unpack some of the points that Professor Daly raised in her keynote address in the inaugural session. If you were to start with and then there can be, and there are many disagreements about how dignity is to be viewed. Is there a core minimum content, or is it in that sense contentless, and there is then further disagreement on whether its shapelessness is its value, and that it's good that it is a normative framework. It provides some sort of framework then that is capable and sensitive to local context and can be shaped in those local contexts, and therefore while there is a unifying structure, it can be infused with local experiences and contexts. And while there are those conversations on dignity, the point being, how does that translate into recognition of constitutional personhood, right? And even if we were committed to the position that dignity in its bare minimum might mean inherent worth or value to every human being, does that necessarily mean that it translates to equal constitutional personhood? And that's a complicated dynamic of which dignity does the law recognize, which does it recognize it equally? And one can think of that in various contexts, in the colonial context, in context of undocumented migrants, and the whole host of contexts, caste, religion, how constitutional personhood does not simply flow from dignity as in a straightforward manner as we might think it does. So to explore many of those issues, we have a terrific panel. And three of us here, alumni, and Professor Daly soon to be adopted, I think, from the. Great. Professor Preetham Barua is the head of School of Law at BML Munjal. And Professor Anshuman Shukla is faculty at Jindal Global Law School, and you've already been introduced to Professor Daly. So we'll have Preetham go first, and then Anshuman, and then Professor Daly. We'll take about 20 minutes each, and that leaves us with about 30 minutes for discussion at the end. Preetham, over to you. Yeah. Yeah.
Thank you, Professor Vasanthi, for having me, and thank you, Anu, for more. Works. Yes. Audible now? Yeah. Okay. So I think I'm the odd one out here because this is placed to be a prelude to a course on dignity, which is also looking at the application of dignity. And there is a dignity law clinic here, which looks at practice. I'm a legal philosopher, and I've done some work on law, on dignity, focused on the Indian court and on the philosophy of dignity. But as I was listening to the first panel and to Professor Daly's keynote address, I felt comfortable that there is space for some of the work that I have done to be spoken of here. And at the outset, I would say that it is very important to have a grip, at least some grip, on the content of dignity, even to speak about indignity. Because we heard in the last panel that, and Amartya Sen actually made that very popular, that you can't have grand theories of justice, but you can spot injustices. I'm skeptical of that view, because how do you know something is an injustice unless you have some sense of what justice is and you put them in the same box? But the idea is a powerful one, that when we see humiliation around us, or when we see treatment that appears to be morally wrong, we are able to spot it better than being able to spot what the meaning of a concept like dignity is. But just to start off, in the history of thought on human dignity, some of which has been spoken of today, there are 4 broad paradigms. And I think it's important to lay it out right at the beginning. The first is, I think, the broadest, and people were very skeptical of it, but now I think, it is coming back, which is the status-based idea of dignity. The status-based idea of dignity being that things have a special status, which is that they have dignitas, right? And that's why we say people who are on the dais, they are dignitaries. All of us who are not on the dais, not so, because they have a special status. And this kind of an idea is etymologically also rooted in the Latin idea of dignity, which is about a status that you might have. But as it is, and the philosopher Wittgenstein told us that as it is, the meaning of words changes, they change with usage. The idea of dignity changed from this status based to what I think now is the paradigm now, which is the Kantian concept of dignity, which focuses on human agency, which is the idea that human beings have the power or the ability to find out what is morally true, what is the morally right thing to do. And that is an ability that we have, and now neo-Kantians say some other beings also have, not just us. And therefore, there is something special about human dignity. Until recently, in the law, it is this idea of human dignity, and Professor Daly also pointed that out, which has taken central space. But Saksham, in the last comment that he made, he said that we might be thinking about dignity of other things. And if you took the UDHR paradigm, and which is human dignity, then I think it would be difficult to think about those things. But if you went back to the old status-based idea, then you may think about the dignity of plants, you may think about the dignity of animals, because it is about treating them according to the relevant considerations that apply to them, given their status. And so plants, depending on our definition of pain, plants may feel pain, they may have emotions, they can communicate with recent research from Germany and Japan. We see that there's a lot more that we come to know of them, but I'm not sure if the idea of dignity captures all of that. Some other ideas might capture. But the status-based idea, I think, still has some purchase in terms of expanding dignity. But in law, we have mostly had Kantian, I think the Kantian intrinsic worth account is dominant. The 2 other ones, one is the honor-based idea of dignity, which finds space in German law a lot. And that honorific account of dignity has often been used to curtail individual rights, mostly the freedom of speech in the law, that to honor dead people, you cannot be writing novels about them which are disparaging of them. And therefore, dignity has been used to limit freedom of speech and censor literary work in Germany. So the honorific account also is there, but it also has deep roots in the Holocaust, which is the idea that human beings have some kind of a honor which ought to be respected, that you cannot bring down at any given point of time. And therefore, it is close to the Kantian idea, but that the honorific idea in law has led to dignity also as a reason for curtailing of rights rather than as a source of rights. And the 4th account, which is not really spoken about, is a more Eastern account of dignity, Confucian accounts. There are some traditions in ancient Indian philosophy where all human beings do not have equal dignity. Dignity in this view, it is called the performance-based view of dignity, that depending on your actions, you will receive treatment which is deserving according to your actions. Just because you are human doesn't mean that you are entitled to anything. Only your actions speak for what you are entitled to. And this can, of course, sometimes be brought together with old Kantian accounts or Hegel's view, on punishment, which is the idea that because we treat you as a responsible human being and we respect your agency, we will treat you according to how you impact the world. And so your performance is the basis of treating you on the basis of dignity. But in dignity in the law, this account has not found much force. Some writing, mostly from Taiwan, and there are people in the City University of Hong Kong, Professor Moon, who has written a book on this Confucian account of dignity, which is a performance-based account. So there are some of these accounts on the table. But what I want to focus on, given that there are these many accounts, is that in the Indian context, we should be mindful of the gap between dignity enthusiasm and dignity inflation. These are two different things. I think we should be enthusiastic about dignity, but it has led to a kind of dignity inflation, which has put us, at least in the Indian Supreme Court's jurisprudence, in a situation where we stand with contradictory accounts of dignity. And that's what I want to focus on in my presentation today. And it is this dignity inflation is mostly this idea, and there are problems with it. People say that, dignity can be used anywhere because we don't really know what it means. For example, there was a critical account by Christopher McCrudden on the Universal Declaration of Human Rights saying that dignity was accepted by everyone because people didn't know what dignity was. So it's easy to agree on something that you don't have strong views about, but you have some intuitions about. And that intuition might have a lot of purchase, it might have a lot of use. We should not really think that because you can't really specify, we should discard it. But the idea is that that kind of, let's say, vagueness about dignity has led to inflation, which is to say that dignity in the Indian context has been said to be a value, a right, a value justifying all our fundamental rights, a value justifying not just our fundamental rights, but also our directive principles. And most recently, dignity not only as a source of rights, but also as a source for limiting fundamental rights. So this is the kind of jurisprudence on dignity that we have today. But what dignity inflation does is that it makes us lose grip on the concept, and that is what I want to be cautious about when we use the dignity. Just like in democracy, when we think that democracy is the sole value, which captures political legitimacy for us, or democracy is the sole value which justifies government for us, I think we should be skeptical of such accounts, because there are many other things such as accountability, transparency, which democracy may capture and sometimes may not capture, but they are important parts of political legitimacy and governance. So I hold the view that even with dignity, we must be clear on where dignity applies and how, and the only way to do it is to work with examples and actual cases and bringing material empirically from the world, which will make us get a grip on it. Now, I want to spend some time on what has happened in the Indian courts, jurisprudence. And there is, I think, some hope here for the reason that though some people like Jeremy Walden argue that dignity is not a moral value, dignity is actually a legal concept. I don't think that in the literature there is much support for it. Dignity is a recent legal concept, but it is a much older moral concept, and the legal concept and the moral concept, they interact in many different ways. And I think that's the moral part which gives a lot of meaning to the legal part when we come to applying it. But what I think the hope with the law is that the law asks you to make things more specific, more fine-grained, and give reasons, which is non-arbitrariness, in your decision-making. And that puts pressure on institutions, on decision makers to flesh things out. And that, I think, has really been a game changer in India. So if you look at the history of how human dignity has developed in India, the Constituent Assembly debates no mention of dignity for fundamental rights or directive principles or for caste or for humiliation or gender. No. It was only the status-based accounts, that the dignity of officers, that who should get what kind of entitlement, what kind of houses should be according to the dignity of that office. That's the kind of discussion we have in the Constituent Assembly debates. If you look at the Constitution, the dignity appears in 3 places, right? Dignity, it's not even one of the capital letter values. It's dignity assuring fraternity assuring the dignity of the individual, and then by amendment, the unity and integrity of the nation. So it ties everything to fraternity, and I think it's a good thing because fraternity makes things more horizontal, and we can really think of dignity in many more useful ways if we tie it up with fraternity. And Professor Upendra Bakshi in his work actually points that out, that at the same time that the UDHR was being drafted, the Constitution of India was being drafted, and we brought something to dignity language, which is that fraternity, which is obligation generating, and dignity, which is rights generating, because dignity is spoken of the individual, while fraternity is about the collective. And therefore, I think we should be comfortable with the idea that we can have obligations towards plants or animals or other human beings, even if we cannot clearly in a Hoffieldian sense bring out a right which really exists in them. It is possible with the new literature in jurisprudence on the, we may call the rights, but I think our obligations towards non-humans. We may have obligations without being able to have a right which they may be able to claim, which a right is a claim, and the claim may not be, one may not be able to make it, but still you may have an obligation towards them, right? So people in vegetative states, fetuses without brains, those are the kind of dignity arguments which are really at the frontier. Now, I know it's around 7 minutes left, but in India, what has happened is that it is really the Supreme Court's jurisprudence starting from Francis Corell-Mullen, which brought dignity in. And I want to mark out 3 paradigms in this. One is that when we started with dignity, from Francis Corell-Mullen, we straight away moved to socioeconomic rights, which is with right to education, then right to food, right to a healthy environment, and several other unenumerated rights. Dignity has been a source of these rights. But within this source, there is a tension. In some places, the Supreme Court of India says that dignity requires the bare minimum required for human existence. So it's not animal existence, something more. But in other cases, it says that dignity requires everything that is required for human flourishing, which means that dignity can be a source for putting positive obligations on the state to a much greater level, like it happens in several of the Latin American countries. Brazil is one of the foremost there, where the constitution recognizes socioeconomic rights in a strong way, and dignity has been used to put obligations on the state to fund individual surgical procedures for people, saying that people have a right to health, and the right to dignity requires that the state funds this surgical procedure. We are not there yet, but it's there in our jurisprudence. The second kind of, I think, paradigm in dignity is that because we made dignity a part of Article 21, right to life with human dignity, and there is also personal liberty, sometimes we speak of dignity as absolute, that dignity cannot be limited, and sometimes we think that the parts of Article 21, we now know that it cannot be suspended, but the personal liberty part is limitable, and if it is limitable, then dignity also becomes limitable. So that kind of a contradiction does exist in our jurisprudence, something to be thought about. The third is that there was a watershed moment in the right to privacy 9-judge bench Puttaswamy case, the privacy case, which I think for the first time the Indian Supreme Court really started explaining what human dignity is. And it brought in a lot of literature from philosophy to say that human dignity is individual dignity, which is about the intrinsic worth of the individual, which is a very Kantian account. That, and that's why later on in the Sabarimala judgment, Justice Chandrachud goes on to say that liberty, dignity, and equality are the founding faith of the Indian Constitution. There is something that links them together. But it was very clear, and I have some quotes, but not presenting it here, but where it has been clearly said that the elements of dignity, and maybe I'll read that out, that brings many things together for us, are respect, 5 minutes, respect for one's capacity as an agent, respect for the choices so made, and respect for one's need to have a context and conditions in which one can operate as a source of free and informed choice. All these 3 elements are about human agency, which is your right to self-determine and make choices for yourself. But right after this, in the 5-judge Aadhaar decision, which is the second Puttaswamy decision, Justice Sikri said that there is a 4th element to it, which is the idea of community dignity. And the idea of community dignity, simply put, and I'll just quote what Justice Sikri said. He said, dignity has a community value which emphasizes the role of the, and this is important, state and the community. It equates, it brings state and community together in establishing collective goals and restrictions on individual freedoms and rights on behalf of a certain idea of the good life. Now, this community dignity idea was picked up by Justice Nageshwar Rao in a later decision of called Association of Medical Super Specialty Aspirants and Residents and Others versus Union of India, to use dignity as a source for trumping individual rights. Now, where does this idea of community dignity come from? So my argument, and perhaps in Q&A it would come out, is that it has no philosophical legs to stand on. If you looked at all the traditions of thinking about dignity, and in the Indian constitution, it is very clear. It is about dignity of the individual. In directive principles and in fundamental duties, it's about dignity of women and dignity of children, right? And doesn't talk about the dignity of the community. Now, the idea of community dignity, if we wanted to really explore it, can be of great value if we were thinking of community dignity, especially specifically in the case of discrimination and humiliation, such as caste or gender. In these cases, you cannot think of any humiliation or discrimination without referring to a group. So you may think of some areas of group dignity where humiliation cannot be expressed without thinking of a group, and there it may apply. But nowhere does this conception say that you can use dignity as a basis for limiting individual rights. Right? What Justice Sikri might be alluding to, and the basis for this actually is also an article by Justice Barroso, who is the Chief Justice of Brazil and the President of the Brazilian Supreme Court, who has an article on this called Here, There, and Everywhere, and Dignity's Place in the Law, I think. And there he brings out this idea of community dignity, but again, there is no reference to any philosophical tradition. There is some reference to communitarianism, but it's not exactly clear of how communitarianism translates into community dignity. So right now, and I have 2 minutes, right now we are in India in a place where we have had around 30 odd years of human dignity being a source of individual rights, mostly socioeconomic rights, and then Puttaswamy, which gives us a lot of material on what dignity is, and then the Aadhaar decision, which tells us that dignity can be a source for limiting your fundamental rights. Now, there is something which I want to pick up, and Professor Delhi said in the in her keynote address, that what is it about dignity that judges really want to go to, why they want to go to it for? And I think that sometimes it's not always useful. Sometimes it's an easy resort to not fleshing out other values. So if you had asked me that, okay, let's think about the right to education. What requires right to education as a fundamental right? I might have picked up social justice as one of the values in the Indian Constitution mentioned in the preamble. So, and flesh that out and said that, okay, this requires. There are many of these underexplored values in the Constitution, but if you easily resort to dignity, by excluding the other values, then I think it is problematic. And the tradition in Indian constitutional jurisprudence has been that we have left the other values and you have gone more towards dignity and picked dignity up and said dignity justifies this. And I think that is something we should be cautious about. But what is the promise and the hope of dignity? And I think that dignity is only one of the instances of the problems that are associated with when moral values are applied by courts. Unlike other legal concepts, there is no definition of these values. There's no definition clause. These values also don't have much legal material. It is much late that courts have given us some jurisprudence of dignity, but most of it is just the mention of the word, no explanation. So in that, I think that things like clinics, things like looking at instances of what we think are the violations of dignity, and courts should be, 3 seconds, I will stop here. And courts should take that mantle up, that they should be willing to, sorry, it's telling me to stop. So Anup's telling me to stop. But the idea is that if courts gave up what I call the Dworkinian view, and which Justice Chandrachud adopted, which is to try and relate all these moral values to each other and then bring out its meaning, and instead had the courage to look at real examples, which is the way of the common law, to look at different kinds of analogical examples and flesh things out, I think dignity has much more hope for us in the place for individual agency, and in the cases of humiliation and group discrimination. Dignity has a lot to bring to the table, but I would definitely say that explore other values when it comes to plants or animals or to other beings. Dignity in the UDHR sense may not help us, even the environment. There are other values to be explored. And therefore, I think that with that hope, we should be enthusiastic about dignity without inflating it too much. Thank you, Anuj.
Thank you, Preetham, for that provocation of what has happened to dignity in Indian constitutional law. And also the challenge for us to think about that the conversation around what is the value and content of dignity might be better thought of as something reinforcing other values than the search for exclusive content for dignity. So thanks for that. Anshuman, I guess a lot of things to relate there on the community aspect and the solidarities from, I guess, from what you're going to speak about. So.
I hope I'm audible. Am I audible? Yeah. So a very good afternoon to all of you, all the guests and attendees. I'm extremely grateful for this opportunity by the organizing committee, a great effort. Just picking up from Professor Preetham's observations on dignity, I primarily agree on the question of the fact that dignity, the idea of dignity is really derived from yes, in this one. Yes, thank you. Am I audible now? Yeah. It's very difficult to gaze it. Yeah. So coming back to the idea of dignity, I'm quite certain, and I certainly agree with Professor Preetham on this point, that what in philosophy we call as morally thick concepts or prescriptive concepts, that they are laid with a whole tier of meanings, right? And therefore, one of the things which one has to observe as especially within the philosophy of language, while dealing with these kinds of concepts, is to look at the synonymical meaning of these concepts. Like, as he was saying, worth, value, it goes on to rank, status, and so on, right? So that part I primarily agree with. Where I have my reservations is, as a realist, as you would see here in this presentation, I'm not so much preoccupied with the problem of contradiction on the meaning of dignity, especially within constitutional jurisprudence, because from the realist point of view, most of the real human problems, as I think Professor Murli was also pointing out, from the clinic point of view, they really don't come to us in some neat categorizations and any kind of a sanitized version, right? Most of them are bombarded like with mixed factors and mixed causations and mixed categories of concepts, right? So at any point of time when you actually deal with litigations and real problems of human beings on the matters of human dignity, it would not be very worthwhile to be trying to search for that non-contradictory, prescription of any kind of a morally thick concept, including dignity. On that point, and since he invoked Wittgenstein, so I would rather say that these morally thick concepts are like, they belong to a certain life form. Every single iteration of meaning of dignity that you derive, it would have some parent background ideology behind it. And in most of the clear, landmark cases of Supreme Court also, you'll find that there's almost like this fierce contestation of those ideologies in terms of trying to search out for the meaning of that particular problem of dignity in that case. And one such case we have with us is this Lieutenant Colonel Nitish Shah versus Union of India. This seems to be the latest iteration of Supreme Court on the doctrine of indirect discrimination and constitutional equality under Article 15 and 16. And while working on this particular paper, we did draw on certain primary insights from moral realism to come up with this whole challenge and problems of dignity, which I'll briefly put down before you here, depending upon the time context, right? Coming back to the question of the historical idea of dignity, which Professor Preetham was talking about, I think broadly the way I see it is, when you go back to the root meaning here, dignitas and the worth and the value of the question of the human person, one of the preoccupations of law, regulation, and moral philosophy has been to look at the negative side of it. That is the silencing of dignity, the undermining of dignity, this whole idea of debasement or subordination of a human being. That is where we mostly pitch the whole notion of dignity. And when you start framing the question from that problematic lens, that dignity is mostly about, within law, regulation, and moral philosophy, it is mostly about a question of its absence, silence, subordination, and domination, right? At once you start seeing a certain kind of an emergence of a prescriptive meaning of dignity, which is held by two important intellectual pillars within Western tradition particularly. One, he has already mentioned, the Kantian deontological tradition, which later morphs into contractarianism of John Rawls and others, right? But the other one, which we have almost passed out, which is socioeconomic rights and those aspects of it, which is the which is the tradition of utilitarianism, right? And these two pillars together constitute one of the linchpins of the constitutional jurisprudence of your dignity rights mostly. One pillar being utilitarianism and the other being deontological contractarian agency and contextual freedom. So that is how, so far, so I can see, I would broadly categorize the constitutional ethos of dignity. Now, what is very keen here to look is, what do these two schools of thoughts really bring in terms of constitutional jurisprudence and their repercussion on the doctrine of state action mostly, right? So when we come to the whole idea or the whole intellectual tradition of utilitarianism, you'll find that, I mean, both of them are tied up with one single fact, because in law and regulation, the problem is that of avoiding debasement, subordination, and domination, and therefore somehow trying to, right, maintain the status quo of a minimal standard of human decency. That is where most of the benchmarking of law and public policy is, mostly, right, with the question of human dignity. When we take both these pillars of intellectual traditions and see how do they maintain this status quo or this least common multiple, so to say, right, of human dignity, they come up with very different solutions for us. One, which comes from utilitarianism, is this extrinsic materialist account of human dignity that basically what we call as roti kapda makan thesis, a food, shelter, clothing thesis. It at once gives us the imagination of a welfare state, a regulatory state. What you'll find is this: it gives us a certain archetype of constitutional state action, and that is interventionist. That is interventionist. So it is not that Article 13 imagination of state action, state shall not do this. It is rather state shall go ahead and intervene in these affairs and secure the minimal standards of human decency, which is basically food, shelter, and clothing, and those whole range of rights. So this is where most of the ideological discourse of utilitarianism comes in when it informs our jurisprudence of dignity within constitutional law. Another way to put the same idea would be what I would call, drawing from Michael Mann's work, the sources of social power, and also Michel Foucault and others. This account of dignity almost seems like an infrastructural account of dignity, a resource-based account of dignity, where one of the important markers of our dignity seems to be our capacity to acquire, distribute, allocate, and also consume relevant material resources, right? Which is roti, kapda, and makan, and those archetypes, right? So this is an infrastructural account of dignity, which is mostly informing regulatory theories, public policy, public education, public health, and most of the other clinical programs mostly are dominated by this ideological discourse of dignity. On the other hand, when you come to the deontological and the contractarian account of dignity, is that your typical Article 13 state action account of a non-interventionist, a state respecting a certain sphere of human agency, contractarian agency, rational choice. And that is where this intrinsic account of human dignity primarily comes from, that human beings, all human beings are laced with certain intrinsic capacity of rationality, and that rationality must be respected within contractual relations. So that is where we get this state shall not do X, Y, and Z under Article 13, right? So just by drawing out these two intellectual pillars of human dignity, you could almost see two imaginations of state action here: the welfarist state action, the regulatory state action, and then the canonical Thomas Paine legal constitutionalism style state action of rule of law, procedural fairness, and dignity basically becoming a product of rules, systems which promote consent and non-coercion. That is a typical Kantian account of human dignity. In this paper, though, we have tried to basically critique that account from the school of moral realism, and also to identify certain interfaces between critical theory and moral realism. That is where the play of the word post-feminism here is basically. So I'll briefly state out this short judicial story for you in this presentation, but I will try to narrate it as a cautionary tale, as a parable. And that is where this key term post-feminism is. It is basically a placeholder for that cautionary tale, that what are some of the typical blind spots of the liberal imagination of rights-based dignity, right? Now, if I get time, then maybe we'll venture further, but I'll just lay out the cards for you here. And then in the discussion, we may move further. Coming back to the case itself, this is a 2021 judgment of Supreme Court. As I said, it is the latest iteration on the doctrine of indirect discrimination. In some of the law schools, the case has already been brought in the course manual and it is being taught. It has a 20-year case history, right? So the starting struggle began from 2003 Delhi High Court, and ultimately it was finalized in 2021 by the Supreme Court in the Nitisha case. The case primarily pertains to the claims of women short service commission officers, WSSCOs, their claim for permanent commission, their claim for promotion to permanent commission. As we know, permanent commission comes with a whole range of employment benefits, and that is a direct bearing on the question of dignity, right? Their internal, first of all, status and position within the military way of life, and also their whole source of livelihood and their long-term planning of a good life. So all of that is baked into the question of their promotion to permanent commission. They had been denied it, this whole claim for time immemorial almost, right? What we see in this particular judgment, that in 2020, in the latest iteration of it, in Babita Punia, basically, Supreme Court upheld the rights of these women officials to get the promotion and rank of the permanent commission within the military. And they articulated, basically Justice Chanchud articulated the entire problem as a problem of constitutional equality and doctrine of indirect discrimination, that the policies of the military bureaucracy mostly disproportionately affected the women as a gender class, right? And therefore it was violative of Article 15, Clause 1 mostly, right? However, here is the first cautionary tale for us in terms of what went on. The government took this particular judgment of Babita Punia and it framed the policies in such a manner where, while outwardly there was a claim of gender, women empowerment and gender equality, however, internally, all those policies were administered in such a manner that none of the women officials could actually get promoted to the PC rank, right? And that is what led to the claim coming back to the Nitisha case, right? In Nitisha case, basically, Supreme Court made three major, findings of constitutional defect within the military's administration of the policies regarding the women officials. The first was their shoddy and casual maintenance of their performance appraisal records, which were confidential. So they were not accessible to the women employees, but they were maintained in a very casual and shoddy manner with a lot of clerical errors. Now, on the face of it, it looks like, lapse of mind, right? But it was tagged up for most of the female officials. And therefore, it led to those particular performance appraisal records becoming a non-show. They were not relevant materials to be considered for the promotion of the female officials. That was one trick of, if I use Michel Foucault's terminology, this was one governmentality trick, right? This was a trick of technology of rule-making by the military bureaucracy to basically undermine the entire jurisprudence of constitutional equality and indirect discrimination as it applied in the Babita Punia case. That was the first. ACRs were compromised, their annual confidential reports. The second major trick applied by the military bureaucracy was in terms of maintaining their medical fitness standard, right? So what was done here was that because these female officials were in their senior ages by now, because they had not got the promotion. So while they were in the junior ranks, their age seniority was up to 45 to 55 years of age. What was basically done by the military bureaucracy was that the medical fitness criteria, which was applied as a normative baseline for 20 to 25-year-old male counterparts, the early entrants in the military, they were ipso facto applied on the senior aged female officials. And by that metric, none of them could actually beat the metric. And the government's simple conclusion was that these are the baselines for the medical fitness, and they have failed it, right? So this is a second trick applied by the bureaucracy, basically here, which leads to complete frustration of the Babita Punia's enunciation of constitutional equality, right? And the third, on which court only touches upon in Nitisha, but which we have picked up quite substantively, is going back to this narrativist account of human dignity and the lived experience part of it. When the female officials had no historical legacy of role modeling, mentorship, training in that military structure, right? Because there was none. And they had no futuristic imagination of a career project of promotion. That was also not there. So there's what I'm trying to say here is that these women officials were basically abstractions of analytical philosophy for the judges mostly, and also for the military bureaucracy. They had no history and they had no future, no past and no future, right? In that kind of a scenario, I mean, if we look at the idea of dignity as a longitudinal life project, right? That whole notion is absolutely debunked and destroyed, right? In this kind of problem. So they were just existing in the moment to moment kind of an ad hoc, reality. That was their reality. What it does actually is this, that because of this absolute lack of longitudinal narrative account of the female agency within the military structure, these officials were not encouraged and motivated to take relevant compulsory courses for promotion. They were not exposed to skill upgradation programs at all, right? All the internal mechanizations of any institution for job promotions were absolutely not flagged out to these female officials. It would be something as absurd as like floating electives and not communicating to you students, or only to some of them and not to the others, right? And then the military comes back and says, well, they have not completed their credit course. That would be what it is, right? So this is the exact argument made by the military in Nitisha, that these female officials have not completed their credit courses to be promoted, right? And so these are some of the, you could say, tricks and mechanizations and technologies of rule making that lay bare the question of dignity from doctrine till administration. That is where my focus here is, right? That what doctrine leaves out, because from the point of view of the beneficiary citizen or the claimant, it doesn't matter what the doctrine has really said, if at the administrative level, it is absolutely undone, right? And the other major, we could say, critique of the code that we have here is, this is not an early republic code. This is not an inexperienced code. This is a code with 75 years history of and experience of administrative review, right? So my humble, one of the explorations that we are going to do in future is on this whole idea of content of a judicial doctrine, especially constitutional law doctrines, that they just can't be a romanticization and this whole, normative accounts of these thick moral concepts. They must actually take a realist approach on the question of potential risk assessments, potential, you can say, leakages, right? Yeah, and therefore, coming back to Professor Preetham's argument, it is not so much contradiction that I'm worried about, but the non-robustness of the doctrine, that the doctrine absolutely fails in most of the circumstances, right? That is where the problem of Nitisha seems to be. How could I change the slide? This one here. Just use. So this is that account, because of lack of time, I'm not going to, but if you look at the second pointer here, this is what I was currently talking about, that this whole distance from doctrine or the constitutional doctrine to the administrative rulemaking is absolutely showcased in the problem of Nitisha. And maybe because of lack of time, I'll not go into the other part of it, but one point I also want to make here, this kind of a, problem of dignity throws open for us law students particularly this whole enterprise of judicial process, right? Its comparison with, let's say, common law adjudication versus constitutional law adjudication. These questions are thrown open, right? What kind of you can say expectation should a constitutional doctrine first of all undertake and then also deliver on to? And my humble suggestion is this, that the constitutional doctrine must always, especially with this kind of a dispute, which itself has a 20 years data history, legacy point. This particular problem of the female officials is 20 years old. So the court could not really say that it did not have the relevant data metrics and the relevant, pointers to be able to anticipate these administrative risks, right? So a doctrine must be as mindful to administrative risks as it is mindful to the normative, philosophical, and the romantic content of it. That is one point we have. The second point I'll not speak because of lack of time here, which is the first point, which is the real crux of the matter on the question of the substantive ideological contestation of the dignity. So maybe in the discussion point, maybe we'll come back to it, right? So thank you so much, right? For now.
Thank you, Anshuman, for getting us to think about how this translation in sort of what is a seminal case on indirect discrimination, how dignity has played out, and how we should imagine what has been done with dignity in that judgment, which is seemingly progressive, and what it means for the longitudinal project. I thought that was a very interesting framework for us to think of. Professor Dali, your own thoughts and maybe responses to some of what you've heard. Yeah.
Thank you. This was incredibly thought-provoking, and I was asked to give my thoughts about this, so I will do that. Perhaps in a little. I'm trying to make it not disjointed, but I was just taking notes as things came up. So I haven't had the chance to sort of synthesize the various points, but let me just sort of jump in. There's this continuing question that has come up already so far today several times and comes up constantly in literature and to some extent more limited in the cases, but about sort of what do we mean by dignity and this question about dignitas and these various sort of conceptions of dignity that have taken hold at different times and in different places throughout the world. And I guess I want to ask you to think about this notion of dignitas that comes to us sort of from whatever, old Roman times or whatever, wherever we go back to in whatever history. The idea of certain people having dignity, only certain people having dignity, was to say that those people, first of all, were important, right? So there's this notion of dignity is associated with a certain like gravitas, right? It makes something important. And that's important is an important word. So just keep that in mind. It wasn't just about importance in the sense that you care about what they say or that they take actions that are consequential. It meant that they had rights, right? That people with dignities had certain rights, and very closely associated with that, they had certain immunities, right? So you can't sue the king, right? There are certain things that people with dignity are allowed to do, and they're immunized from consequence about it. And also closely tied into this, and this is just sort of the fourth word that I would invite you to think about with respect to people of a certain status having or rank having dignity, is that they were either the sovereign or in some way associated with the sovereign. If they were nobles, they had they stood in the place of the sovereign at certain points. So these ideas of importance associated with rights, associated with immunities, and associated with sovereignty, those are actually all very much part of the way we think of dignity today in sort of the modern jurisprudence of dignity, right? When a court says that something or someone has dignity, the very first thing they're saying is it's important, right? We need to pay attention to this. This is something we should focus on. And as I mentioned earlier, and as we all know, and that's why we're talking about it not in a philosophy forum, but in a legal forum, it's associated with rights. To have dignity is to have rights. So the question, for instance, about rights of nature is sort of associated with, are they important enough to have rights that we should pay attention to what they say, what they are said to say or whatever. And thirdly, that they're associated with immunities. The idea of dignity, even in the modern sort of UDHR version of dignity and common constitutional jurisprudence of dignity, is that to have dignity is to have certain immunities. If I have dignity, there are certain things you cannot do to me, right? Like torture, for instance, just to give the easiest example. Whereas if I didn't have dignity, if I was a blade of grass, other than in some religious cultures, but in others, if you're a blade of grass, you can quash a blade of grass, and that's acceptable. If you quash an entity with dignity, that's not acceptable, right? So to have dignity is to have rights and to have certain immunities, have certain protections from what other people might do to you. The notion of sovereignty is also really important and interesting. In the US, there's a whole jurisprudence about state sovereignty, right? That has, that is there. But what sovereignty really means is to be, to have like in the national, under international law, for states to have sovereignty, first of all, it means that they have certain rights. It means that they have certain immunities, right? They can't be invaded, right? And it means that they get to control things within their borders. But that's exactly what we mean when we think about human beings having dignity, is that I get to control things within my borders, right? My body, my privacy, my sense of self, whatever. I am in complete control of that. And to have dignity or to have sovereignty is to say, nobody else can make decisions for me. I make decisions for myself. So to me, a lot of the sort of the conversation about the source of dignity and what form of dignity or what classification is not necessary to have a full understanding of dignity as it's used today in constitutional jurisprudence, because in a lot of ways, it just sort of comes down to the same kinds of things. And I want to sort of appreciate the four categories of dignity that you sort of ways of thinking about it, and you mentioned sort of two of them. And I want to add another one to this, and they all, you know, again, I think it's worth spending much more time than I have right now to really sort of look at the categories and what do we learn from these different traditions. I was fortunate enough before coming here in September, actually, to spend a month in Bhutan and spent a lot of time with the Dignity Clinic there and trying to understand the meaning of dignity in Bhutan. And so, of course, in that tradition, and this is based on my extraordinary expertise based on months of conversations there. So for what it's worth, just a few thoughts about it. One is that, of course, the idea of human dignity is there and is part of the law and part of the consciousness and part of the way of thinking. From a from a Bhutanese Buddhist perspective, it may not be limited to humans. Dignity may apply to all sentient beings. So that's one way of categorizing it. When we think about rights of nature, are we just thinking about sentient nature? Or it may go broader and say to all living things, or it may go even broader than that and say to all things. So there's different ways of categorizing or different ways of explaining who in this society is important, has rights, has immunities, and ought to have some way of controlling themselves, even if it's through like a guardian ad litem or something, somebody who speaks for that entity who doesn't possess legal knowledge themselves. The other thing I just wanted to mention about the Bhutanese experience is that in Bhutan, the notion of dignity, which is very much accepted and very much embedded in the law, is also very much connected to happiness, right? To gross national happiness. And there's a wonderful sort of confluence, again, not the same thing. Dignity and happiness are not the same thing, but a real strong confluence of that. And I just want to mention that because it's a word that we haven't talked about so far, but I think it's really important to thinking about the human experience. So there's that. A few other comments, and I guess I really like the idea of distinguishing or just sort of calling out dignity enthusiasm versus dignity inflation. And that whole notion of dignity, I think that's a great word to use to describe sort of a whole set of issues around using dignity when you don't really mean it, or you're using it to say that something's important. In something I wrote a long time ago, I read all the US Supreme Court cases that mention dignity. And of the 1,000 cases, most of them were about the dignity of a contractor, the dignity of a river, or the dignity of war, the dignity of something, Congress, courts, whatever it is. Very, very few about the dignity of a human being, but that's a whole other issue. But I just want to mention the idea of using the word dignity in a way that may seem somewhat inflationary, just to say, hey, I'm saying something important, so listen to me. I think that, and I haven't really thought this through, so this is truly first impression, first instinctive response, or is to question whether we can keep our enthusiasm for something that seems like it's doing a lot of really good work and doing things that we want the law to do, without going into sort of this inflationary mode, by focusing very squarely on the cases. And so I appreciate your sort of case studies and saying, this is exactly what's going on. This is where dignity matters. This is where it doesn't do the work that we want it to do, et cetera. And I think that, so I was writing notes very fast. I can't quite read all my writing, but that's okay. Yeah, so I want to sort of invite us to think about dignity as it's actually being used. And I think for me, at least, that's my comfort zone, because I'm not a philosopher, but I am a law professor. So I do spend a lot of my time reading cases and just trying to figure out what those cases mean and how the court has, in any given jurisdiction, has been applying specific concepts to make law real, to sort of bridge that gap between promise and practice, right? So I want to sort of invite you to, on a thought experiment, this sort of theory I have about dignity law, which is unprovable, but I want to suggest a thought that I've had. and ask if it makes sense to you. If, suppose a spaceship from outer space landed somewhere on Earth, pretty much anywhere on Earth, and aliens got out of the spaceship and sort of looked around at Earth and said, what are all these things that are moving about? And some really smart one of these aliens said, oh, I think they're called human beings. And the other aliens in the spaceship said, well, what are they? And they couldn't figure it out. They couldn't figure it out by looking at what human beings do. They couldn't make sense of what human beings do. And one of them got a brilliant idea, brilliant only to a mind like this. Let's read the dignity cases and see if we can figure out what these human beings are. Because my theory is this, is that if you read this global jurisprudence of dignity, you will learn what human beings are. And in fact, I think that that's why, despite the fact that we're seeing cases on so many different issues and so many different cultures from so many different countries and all that at different times, now we've had decades of jurisprudence on this, as you've said, the reason there's this overlapping consensus is that what's important to the courts in these cases, not in the inflationary cases, but in the cases where dignity is really being used seriously to solve a problem, what they're really concerned about is what does it mean to be human in the 21st century? How should the law respect the human being in the context of a particular case? So let me tell you a little bit about what I'm thinking. These are some of the cases that aliens coming out of the spaceship would find if they happened upon a dignity law library and read the cases. They would learn, first of all, that human beings are biological beings, right? We've talked a little bit about this. Human beings are things that require food and water. They require certain protection from the elements, right? They need shelter. They require, their bodies get frail sometimes and they require support, or what we would call healthcare, right? To help with their bodies. They would get all of this from the cases. Then they might come across an Indian case. And I don't have time to sort of quote from a lot of cases, but everything I'm saying comes from some case or another, or more cases, but this one I will quote. You can acknowledge if you recognize it, where the court says, well, the right to life enshrined in Article 21 cannot be restricted to mere animal existence. So suddenly these aliens are learning that these things running around like this on 2 feet are kind of like animals in some ways because they have these biological needs, but they're not like animals in other ways. How are they not like animals? It means something much more than physical survival. Every limb or faculty through which life is enjoyed is thus protected by Article 21, and a fortiori, this would include the faculties of thinking and feeling. And suddenly these aliens are saying, okay, they're biological beings, but there's this other thing called thinking and this other thing called feeling. Now, what's all that about? So they have to read more cases, and lo and behold, they find more cases about thinking. They find a whole series of cases from India and elsewhere. I'll try to do this. About education, right? Things that help us think. In the case from the Inter-American Court, there's a newly established right to science. I think that's brilliant, but okay. To help education. And the purpose of the education is to help, not only help them think, but help people fully develop their personalities. They would read the case law and see lots and lots of interest in fully developing the personality, whatever that means. And then these feelings. So there's a lot, obviously these human things are really interested in feelings. They're very interested in emotional well-being. They're interested in self-esteem. They're interested in how they feel about themselves. They take their hopes and their dreams very seriously. There are cases about dreams, not in the sleep sense, but in the dreams of your dream for your life, right? Your life project. There are cases about hope as an aspect of dignity, right? So these human things have feelings. They care about how they feel about themselves. They have hopes and they have dreams. They all want to be treated equally, but they also want to be treated as an individual. So at some point, they're starting to read these cases and they're getting, it's like being in law school at first, where the more you know, the more confused you get. So this is what the aliens are going through. You should have sympathy for them. They each want to be treated as an individual. So these dignity cases are a lot about how you'd have to treat every person, as their own person with their individual needs. Cases about gender identity, for instance, are very common cases about things like that. These humans are also very concerned with something called humiliation. They tend to feel it a lot and they want to protect themselves from it. So we have to worry about that. Sometimes they get humiliated from exclusion or discrimination, domination, those kinds of things. So we know that humans have a sensitivity towards that. Sometimes they're just humiliated from discrimination, or just from being treated differently. They're not only concerned about their own self-esteem and self-image and self-worth, they're very concerned about what other people think about them, concerned about reputation, a lot of dignity cases about reputation. They're even concerned about what people think about them after death, sometimes before birth. They're very concerned about their own privacy, but they're also really want to be connected to other people. Families and personal relationships are very important to them. This is very confusing for the aliens. There's this thing called marriage, and sometimes it's really important to get into one, and sometimes it's really important to get out of one. Sometimes it's really important to have children, but sometimes it's really important to not have children. There's this thing called sex that the aliens don't understand at all, but humans apparently really like it, but also really want to say no to it. It gets really confusing for the aliens. But it's not just family, it's also community. Aliens want, sorry, not the aliens, the humans, want to be connected to each other. They want to have these relationships with each other. And they want to feel connected on the basis of their choice about who to be connected to. So the aliens are getting this pretty broad sense, right, of what it means to be human from doing nothing but reading these cases, because that's ultimately what these cases are about. What do people need, and what should the law do to reflect and protect what people need? Then the aliens start getting more sophisticated about this. They're reading more and more cases, because how can you not? They're fascinating. And they learn about this thing that humans created called states. And now the aliens are really confused, because humans created these things called states and then gave them a whole bunch of power. And now this thing with all this power is actually abusing the humans who made it. And they're really confused about that. And so they see in all these cases that this line between the state and the individual, who has power to make a decision. And by state, I mean maybe also, I definitely mean states as in nation states, but also maybe communities and other entities. And that gets into that whole question of who has the authority to make decisions for you. Is it just you, or is it also your community and your state? And all of this gets really confusing. Now, I don't believe that makes the law about dignity, it does make the law about dignity confusing, can't deny that. But I don't believe that that's because the law about dignity it doesn't make sense. It's confusing because it's actually trying to do a really difficult thing. It's trying to shape the law to what people need. I had an opportunity earlier this year to interview Justice Albie Sachs, formerly of the South African Constitutional Court. So if you know about dignity studies, he's sort of a lion in the field. And he was talking about some of the cases that he had decided as a justice on the first Constitutional Court of South Africa. And he was talking about how messy these cases were. They're complicated, they're messy. You get your hands dirty when you get into it, right? And he said, but that's okay, because human beings are messy, right? And that's sort of the point. This area of law is very difficult to wrap your hands around, because what human beings want and need in order to protect what's so important to them is so complex. Thank you.
Yeah. Thank you, Professor Daly, for those reflections. For the students here, if you haven't read Albie Sachs's autobiography, I strongly recommend it. The Alchemy of Life and Law, easily one of the best legal autobiographies written. So, okay, so we have about 25 minutes to 1:30. We can take questions. And while you frame your thoughts, I'll just kick it off with the three of you. I mean, in this, while I was listening to all the comments, I was reminded of this essay, Savages, Victims, and Saviors, the Human Rights Paradigm, by Makau Mutua, who makes the point that is largely talking about international human rights and the concerns with that. But largely the problem was, why I wanted to use that was the framework, the idea that this is then used, dignity, and he talks about this in the context of human rights, about how human rights are used to mask values, right? In the name of that certain persons and experiences are seen as savage, some are seen as victims, and then the savior comes in the form of human rights, but that human rights actually masking values. In that sense, does dignity run that risk in terms of, given its indeterminacy, it also then is ripe for masking preferences in sort of more normative, value-laden language? And how do we guard against that? Yeah.
Yes, so that's one of the allegations first made about dignity being a smokescreen. So it is useful in being a smokescreen in terms of cultural relativism can be accommodated, which was spoken about in the first panel. But at the same time, dignity, especially in the case of women's rights, has been used, and we know in India, dignity of the woman is often used as a way of curtailing rights, saying of what the community wants rather than what a woman wants. So it is an allegation about all vague values. But the answer to that is to actually flesh it out, that, every time you use a value, especially by courts or legislatures or executives, which are authorities who take away our freedom, they ought to give reasons. I think those kinds of a reason-giving view of, adjudicative bodies and authoritative bodies demands, in this messiness, demands them to stick out their necks and state why they think someone's right is denied or why someone's right is protected. So I would say that definitely they are used as smoke screens, and I have something to say maybe later on legal realism. And I don't, sometimes they mask biases, which has happened, I think, in the case of, I forget the case now, which was in Bulgaria, where dignity was again used to curtail individual rights. I'm forgetting now that case, but you would see dignity is often employed on both sides of the argument, pro-abortion, anti-abortion, also in cases of individual rights, pro-individual rights, now pro-community rights. So definitely, but the answer is that every time a court uses it or an institution uses it, you flesh out and you give reasons and you give instances of where it works, where it doesn't work. Otherwise, I think there are problems. Yeah.
Professor Daly, in that sense, does it force a certain, is its value lie then in that it forces a certain justificatory framework while deciding these really tough cases, complicated cases, that you have to resort to, and there's value in forcing judges to resort to the argument of intrinsic worth of human beings, that you lay that as the framework within which this adjudication has to happen?
I had a really long-winded, complicated answer to your first question, but your second answer just is exact. I think that's exactly right. I think that's exactly what it does. And to go back to just the fleshing out, to me, that's what the cases are so valuable for. That's why I love reading these cases, is because they provide a vocabulary. Dignity is such a great shorthand. And of course, right, it makes everything more important. So it's really, I mean, that's your inflationary point, but it's so appealing to just use on any side of an argument. But if you look at the cases, it's not saying it's anything. It's saying it's something specific. And I think that there's a conversation to be had, and I don't know if right now is the time to do it or some other time, but about the tension between individual dignity, locating it in the individual, which I think the UDHR very emphatically does for all kinds of reasons, and using community dignity, which often is invoked in order to curtail individual dignity. And I pause because I'm not sure if there's any other time to use it. But so I think that's a whole other, that's a piece of it that's really important because it keeps coming up. But your point is very well said.
Yeah, Anshuman, you can also respond, but just one more question for you in terms of, could you also additionally comment on, even if we change the phraseology from community dignity to group dignity, for whatever it's worth, right? Is there, especially in the Nitisha kind of context, the limitation of what I heard you saying is that there's a certain limitation of individualizing this too much, right? There's a certain danger to it. And the group element of this needs to be thought of. So if you could just reflect on that as well. Yeah.
Just to connect both the points here, the question you just asked and the way Professor Daly was articulating this individual versus community dignity, right? As a kind of an schism. Now, again, within political realism and legal realism, you'll find that the fundamental rights or rights in general are not really conceived within this school of thought in this neat categorized manner. Most of them overlap with each other. In real problems, they always contest with each other also. There's almost like an implied metaphysics of ranking of these rights, like freedom of religion certainly is of a lower tier than compared to right to life and others. Just by the framing of those rights, you will find that kind of a metaphysics. So not even all rights are realistically created equally within part 3 itself, right? So coming back to the dispute side of it, most of the times what we find in milestone cases, like landmark cases, you pick up Bennett Coleman, you pick up Olga, any of those, it is not so much state action on one side and a fundamental right of a citizen or a group on the other side. It's mostly a contestation of rights versus rights on both the sides. That is what really makes a case a hard case, right? And the other part about the schism between individual as a marker of dignity or a holder of dignity and the community, most of the times in those cases, like, yes, certainly that is one usage of the schism to pit a legal dispute as where the dignity of the community is used to curtail or to offer public exceptions to the individual's rights. But there are a whole series of cases, especially these ones which he's talking about, like Nitisha, where it is not so much the community's dignity being impingement upon individuals' right, but rather community versus community kind of a problem where there's a whole question of historical marginalization and silence and so on. So it is not really that the espousing of the community's dignity and rights leads to curtailment of some other individuals, but rather the propping of the individuals within those communities as a marker of fellowship. So here, when we use gender as that category, the flagging of the gender construct within the military structure is not really impinging upon the individual person's dignity, but rather espousing the claims of the female agency as a group. So that is one way in which you can get it.
Yeah, so questions, yeah, just try and keep it short. And if you just introduce yourselves as well. Yes, please.
Hello, yeah. Hi, I'm Abhineet, I'm a lawyer. My question is to Professor Preetham. You said that the idea of dignity that law has is basically a Kantian idea. But when we sort of try to understand what a Kantian idea of dignity entails, we usually come to an explanation that sort of resembles a definition of autonomy. And that has been a very consistent critique of the concept of dignity. Ruth Macklin being like one of more famous critics who said that if we actually dig deeper, what the concept of dignity boils down to is basically autonomy. So is the argument that what the content of dignity is basically autonomy? Because if that is the sort of line of thinking that we're going with, I think that will find purchase in Justice Sikri's opinion and the other judgment which you mentioned, where the explanation of dignity is very autonomy centric. Obviously, he mentions community value, but does not sort of define it with the level of precision that he does the concept of autonomy. So the question that I have is basically, obviously, like, I'm not denying the fact that the concept of dignity does a lot of heavy lifting when it comes to social criticism. And probably that social criticism cannot be emulated by the concept of autonomy. But when we talk about rights, is the concept of dignity basically identical to the concept of autonomy? And if it is not, what does the concept of dignity add to the concept of autonomy? Thank you.
Preetha, and I think Professor Daly also wants to respond to that.
So if one were fair to Kant, then he uses autonomy as a part of the explanation of dignity. So autonomy is the ground for dignity, being the ability to go through the steps of giving a law unto yourself is being autonomous. And because we are autonomous, we have a high status of dignity. So the arguments by scholars like Ruth Macklin and several others who are in the bioethics sphere is to say that other ideas like equality or autonomy do the work for dignity, therefore we don't need dignity. But neo-Kantians come back to that and saying that your idea of autonomy is an integral part of the Kantian idea of dignity, which is autonomy expresses your agency, and dignity captures this idea that you have this special ability to give moral norms to yourself. That's why you are autonomous, and that's the ground for dignity. So one might say that if we were just playing with semantics, then we might say the words dignity, do not do much work, rather autonomy does much of the work. But where does it do the work? Again, it does in the Kantian conception of what autonomy is. So I would put it this way, that in terms of the court, it doesn't matter whether we choose autonomy or dignity, because the property in the world that we are trying to get at is the ability of people to decide for themselves, and that ought to be respected. Autonomy also captures it. And in Justice Sikri's opinion, community value is not in that constellation of concepts. It's in a different constellation of concepts. And therefore, I think it is contradictory, and therefore it is difficult. But to the Ruth Macklin idea, I would say that if, even in the groundwork to the metaphysics of morals, Kant uses autonomy as a part of explaining the idea of dignity. And therefore, I don't think that that's a real challenge. The real challenge would be, equality does the same thing that dignity does, so it doesn't matter. Then you will think, okay, now which idea of equality? And then that's difficult, right? But yeah, so I don't know if I've answered the question, but those are the thoughts that come to me. Yeah.
So I'm not sure if I want to say something different or actually build on that, but I guess both. So I have, I think autonomy is very different from dignity. So I'll just, that's my starting point. I think it's very different because autonomy, the ability to make a rule unto yourself, assumes that we're living on islands and that nobody else matters and I can just make whatever decisions I want. And that's obviously not the real world. So I don't think that autonomy, that word itself, like using it in that strong form of decision-making authority, if you will, is really that useful if taken literally. I think agency is a much better word to use to connote that without suggesting that I'm the only one who matters. I think that certainly in the UDHR and post-UDHR world, but I think also in Kant, the notion of dignity embeds within it the notion of reciprocity. If I believe in my own dignity, it's a part of the fabric of dignity that I must believe in your equal dignity. So autonomy doesn't require that reciprocity. Equality kind of does, but equality doesn't have anything to say about agency. So what dignity is doing is bringing those two things together and saying, I do have control over myself. I do have what I referred to before, sort of the sovereign power to make decisions for myself, but I also have to recognize that sovereign power in you. And I think that's such an important difference between freedom or autonomy and dignity. Freedom means I get to do whatever I want. And it doesn't, I'm not worried about the consequences for you. Dignity means I have to worry about that. That's why in Article 1, we have to act towards each other in a spirit of brotherhood. If we're going to accept dignity, we're going to accept that they're rights, we're going to accept that there's a spirit of brotherhood within us.
Sorry.
Hello. So I have two questions. One for hi, I am Saksham. I am a fourth year law student at NALSAR. I have one question for Professor Preetham and another for Professor Anshuman and Professor Dali. So to Professor Preetham, you mentioned how to ground dignity, what we need to go into is this common law culture of exploring a lot of different cases and have that empirical backing to it. But Professor Dali, throughout her 20 minutes remarks, provided us how, and as Justice Sachs provided, that it's very complicated, humans are messy, there'll be a very varied differences of factual matrices. So how do you harmonize, because she's providing that there's so many different factual matrices, and that's your strategy effectively. So how do you harmonize to provide a solid grounding to such variety, such messiness is there? To Professor Dali and to Professor Anshuman, this question comes from the recent committee judgment of the United States Supreme Court, where they effectively, there was a challenge to a law banning gender-affirming care to transgender adolescents. And now the arguments made there by petitioners didn't rely on dignity, it was relying on equality, more so to align with this Bostock ruling to appeal Justice Gorgeous. But what I wondered, and the judgment also didn't answer this as well, is dignity, because of its grand romanticization in the legal sphere, its potential for grand romanticization in the legal sphere, allows it to be a uniquely strong element to argue for the most marginalized, especially dealing with hostile realist courts, as is the case with the US Supreme Court, which we know is a very actively politicized courts, and to deal with what judges we have in this country as well. So does that make a unique capability to trump legal realism? So I hope my questions are clear.
Yeah, first of all, a very, very interesting discussion. Thank you for that. Just a thought that was occurring is that in our fractious times in which we live today, there is also a huge potential of the word dignity being misused by all kinds of vested interests to suit their ends. And depending on which community is dominant, like you said, no, it's community rights versus rights. Ultimately, the word dignity is playing the role of, being used to suit your end. And the real meaning of dignity is getting lost in that way. And it's a very, very difficult thing to negotiate today. I mean, we are facing it in India very much so.
Hi, I'm Karthik, I'm a lawyer. My question is to Professor Barua, and at the same time, I would be happy if Professor Dali and Professor Shukla would add on to it. I simply seek to understand the concept of group dignity in more detail. Firstly, Professor Barua rightly connected the historical and philosophical understanding of dignity to the individual, and also very rightly warned about dignity inflation. But Professor Shukla also very rightly pointed out the longitudinal and lifelong indignity attached to being part of a group. And it clearly seems that group dignity is something that should be valued. My question is it necessary for us to completely ignore this concept that is group dignity just because it lacks historical or philosophical basis? And if we do consider that this concept is important, then how would you try to formulate it?
Thank you. Thank you for the wonderful presentation. My name is Satya. My question is to both Professor Preetham and Professor Dali. And I am also thinking on the same lines as to how can dignity be a more useful anchor or a value in thinking about anti-discrimination law. Professor Daly, you said that to have dignity is not to be reduced to a thing or not to be dehumanized. So in that, my provocation is that do we need to narrow the invocation of dignity to some instances of wrongful discrimination and not all? In other ways, while all discrimination are immoral, all discriminations are not equally immoral and not equally dehumanizing. So can we look at dignity as an antidote to certain kind of discriminatory emotions like humiliation or disgust? Because these would these address those situations where there is complete rejection of humanity of an individual belonging to a group vis-a-vis rejection, vis-a-vis reduction of humanity. So former would include cases like caste-based untouchability or discrimination against transgenders or sexual minorities, vis-a-vis other cases of systemic injustice against women, where there is reduction but not complete rejection or making them seem as an inanimate thing in itself. So how can we make anti-discrimination law more robust to factor in these deeper divisions of discrimination? Thank you.
Seeing that we have 5 minutes left, maybe each of you can just respond to the questions that you do want to respond to. Yeah.
So first question is on messiness. See, the strategy of the common law is exactly answering the question of how to deal with this messiness. So we recognize messiness, all right, but then how do we deal with it is the question. So I would suggest that when you have something messy, it means that there are many different things that are going on. They seem to be overlapping, but the strategy of the common law is to find out patterns in this messiness of instances, and then try and sometimes isolate, sometimes combine to say that, you know, these analogies work, therefore this principle applies, and those analogies work, therefore this applies. But the idea is about spotting patterns. This is what human minds also do, that when there's a diversity of things and there is a disagreement between some of them, you need to make a decision. Then you try and generate agreement, and you generate agreement only by pointing out to more sources that ground or firm up your decision rather than others. So the history of law, and it's the business of law to sort out messiness. So I think that sometimes this messiness argument, oh, it's so messy, so hands off. No, that's where the argument, the work of law starts. So I think that working on principles, using moral values and drawing them out by showing that this is a pattern which lies across several cases has been a traditional way of working with the law, and it works very well in terms of justifying many cases. This is how we go on. We say that, okay, see, there are these similar cases, same principle justifies, therefore this applies here. Otherwise, it doesn't, right? So, and that's why I think messiness is not an issue for this. Rather, it is a strategy to work on messiness. The second question on misuse of dignity, I very much agree with you that when there is misuse, it means that people are not paying attention to what is a correct use. And despite acknowledging that the use will always change, we must take out what we think is the correct use. And therefore, I am a fan of individual dignity, for the reason that I think that cases like the Nishita case, cases of gender, caste, they can also be explained on individual based arguments. Just because there are not many people who belong to a category doesn't mean it's wrong. It is wrong because you're applying an irrelevant consideration of what you take a human being to be. So I'm a fan of the individual one and the idea that individuals build up the collective. And so to bring out the misuse cases, it is very important to put the pressure on them to say, how is it dignity here? Which concept of dignity? How are you applying it? That's the only way forward. To Karthik's question of group dignity, I think group dignity is used. I find it still difficult to find an known account in the history of the word of dignity where we can apply it to groups. But group dignity, the idea definitely alludes to questions of humiliation, that certain kinds of humiliation can only be understood because you have been bracketed into a group. So caste, gender being such things. But you will also find that the individual arguments apply there too, which is to say that it is wrong to say that an individual is lower than someone else. Or in the Lieutenant Colonel Nishita case, it is wrong to apply a 25-year male's principle to someone who's a 45-year-old female because you take cultural feminist theories, difference theories, and say they are different. So you have to be sensitive to their condition and apply a relevant consideration, which is an argument from equality, by the way, substantive equality, and you can get the work done. So I think it is this way that the individual argument works. The group argument helps in spotting egregious violations and then taking note of them. And therefore, I think that we should not think of them as two disconnected ones. Rather, one enables the other. And in Satya's argument, discrimination, one way of looking at it is dignity as an expressive norm. Tarnath Khaitan has written about it. But the point which I feel really strongly about is that all those questions of discrimination where you are subduing the agency of an individual are dignity apt cases. And I would therefore ask, sometimes I ask the realist this, that you find out, oh, there is domination. Why is domination wrong? You found out that in the Nishita case, all these things happened. You apply the wrong norm. Why is it wrong? Only a moral value will tell you why it is wrong. And in such cases, domination is wrong because you have subdued someone's agency, privileged someone else's. And critical legal studies is right in spotting out that the law doesn't take note of it, rather it puts blinkers on us. But it doesn't take away the liberal argument that when you make the normative argument, you will rely on dignity or autonomy or some such in order to make the normative case. So I think that agency-based questions apt discrimination questions for dignity. Some others, immutable characteristic questions, have some relationship with dignity, but questions of there are other concepts which may explain it better. But in law, we must do this fine-grained analysis and not take our hands off from it.
Yeah. So this one particular question that I think you asked about gender affirming care, right? So now, although I'm not well versed with that jurisprudence, but one of the common themes in this particular panel, and I hope will be throughout, is this purchase value of dignity. We are constantly asking, can dignity as an idea be replaced or substituted by something more practical or more ever present, like equality, justice, and so on? And it's here again that my mind is basically taken to moral realism, that one has to upfront ask, what is this purchase value of dignity here, basically? What is so unique and precise and hammer and tongue about the idea of dignity that may not be replicated by some of the other concepts? And when I go back to the whole, scholarship of ethics, basically, right? Not morality as in moral prescriptions, rule-based deontology, but ethics, right? Ethica as in character, human character, and facing, highly cacophonous and noisy and confusing reality, that kind of a ethics, right? One of the things you'll find is this purchase of moral sentiments, that most of our moral concepts are not really abstracted out only through rationality and reasons, but we are extremely moody people, right? And a lot of our moral judgment is laced with a whole spectrum of moral sentiments. And I'm not the first one to be saying it. Starts from Aristotle, goes to David Hume, and so many others, Martha Nussbaum and others, right? I think when we start looking at these moral concepts or these questions of rights from that angle of moral sentiment, immediately we could at least conceive in principle one of the unique purchasing value of dignity, that it is a very raw and primal concept. And to come back to your question, I'll rather flip the script and say it is not romantic, it is primal. And that is where it becomes maybe perhaps more useful to the niche, historically marginalized communities, because it is so primal and raw kind of a concept, right? Because it is laced with moral sentiments. Some of the moral sentiments I'll cite to you rather than, theorizing about it. For example, going back to these two pillars, deontology and utilitarianism, the moral sentiment which is backed by those two pillars is tolerance, empathy, kindness, and on that spectrum, as you slide, you go to benevolence, and then you go to paternalism. Right, that is parents, patria, welfare state. That is how the moral sentiments basically slide on that. When we come to the realist side of it, two of the important moral sentiments which seem to be missing from, coming back to the question of anti-discrimination doctrine also, how could we make it more robust? And that is where the first flag point of the this Nidisha paper was, basically, which I failed to mark out because of the lack of time. That one of the important makers of, or the markers of human dignity seems to be our commonality, our shared, values and our attributes, rationality, roti kapda makan, and all of that which we all share as human beings. But what we fail to realize is also this, that in actual setups, in actual disputes, in actual human transactions and relationships, a significant residue in ethics, we say, of dignity or value lies in our moral appraisal of others' uniqueness and specificity. right? And that is where the question of non-utilitarian conception of dignity comes in. And that is where the moral sentiment of praise and admiration becomes extremely important for recognizing the dignity of another person or another group. It is not just tolerance, empathy, kindness, and care which will, complete the picture of dignity of the other person or the other group. It is also praise and admiration. And that, so in this particular paper, we were basically trying to flag out that comment that the court has absolutely missed out the uniqueness or the role that women could bring within the military side. That part was absolutely silenced. So to come back to your question again, I think because of this primal nature of that concept, it is so laced with moral sentiment that it might find a lot of application in those niche areas of anti-discrimination. Yeah, because of lack of time, I'll not go much further than that. But
Thanks, Anshuman. Professor Daly, will end with you. Yeah.
So there's a lot more to say, and I'm glad that we'll have the next day and a half to sort of flesh out some of these issues. I think the only thing I want to say right now is just to remind us of one of the aspects of dignity that we haven't really emphasized that much, which is the idea of worth. And of course, that's sort of the noun. Everything else is the adjectives of dignity about universal and equal and all that kind of stuff. But the noun is worth. And the worth of humans is intrinsic, right? That's ultimately the point. Humans have no purpose. So if we have worth at all, it's not because we're accomplishing something in an instrumental way. If we have worth at all, it's just because we have worth as human beings. We've decided that we have worth. Nature can make the same claim, or we could say the same thing about nature. Other things, not so much, right? Everything else is a human invention, whether it's states or corporations or tribes or communities or whatever else. We've invented those things to accomplish certain goals, and we can measure their value by how well they accomplish those goals. But you can't say that about humans. And that's the commitment of human dignity. And the other thing I want to say about worth is, and so that's there's sort of questions about discrimination and group and all that kind of stuff. And maybe the notion of intrinsic worth is useful in thinking through some of those problems. And then the other thing that I'll say about worth is that for a dignity violation to occur, it has to go to sort of the heart of someone's sense of worth. If you look at discrimination, in my view at least, the harm of being discriminated against may, in many instances, and certainly in the kinds that get to courts and get to Supreme Courts and that we talk about and that we worry about, the harm of being discriminated, of being marginalized, of being made to feel less than, is a true dignity harm because it goes to your own sense of worth, right? And that's the thing that sort of should be forbidden in this dignity paradigm world that the UDHR set us on a course for. The need to discriminate, whether it's justified by a policy or a practice or a religious view or whatever else it is, may not go to the worth of the individual. I may not have a dignity-based need to discriminate, but the harm is dignity-based. And so I'm not sure that, and I think if we think about that in terms of what goes to the heart of intrinsic worth, we may be able to sort of separate some arguments that are so-called dignity arguments versus other arguments or cases, in any case where we're talking about it, where there's two sides. It's the rare case where both sides really have a dignity claim. Abortion may be one of the very few examples of that, where there's true dignity claims on both sides. We can argue about that, but I'm just sort of putting it out there that it's there. And notice what the Indian Supreme Court and several other Supreme Courts since 2022 have done in response to what the US Supreme Court did, or in sort of reaction to it, was to say the dignity right to control, to make decisions for oneself about reproduction, that is a dignity right. It's inviolable. And that means that whatever other interests the state has, and the state may have very, very good interests, may have very, very strong interests, But those interests must be done in a way that doesn't undermine and that actually respects and promotes the human dignity that is there. That's sort of the way dignity cases can often come out. You can accomplish your goals. You can do all the things you want to do. You can have the best army with the most fit people and all that kind of stuff, but do it in a way that doesn't demean the intrinsic worth of the people who are thereby affected. More to come this afternoon.
Thank you. Thank you, Preetham, Anshuman, and Professor Dali. So much to think about, and I'm sure many of these issues will keep coming back in the sessions ahead. We are back at 2:30. So we'll be back here at 2:30 for a session on how various aspects of dignity has played out in the criminal law clinics that some of us have been involved in. That promises to complicate this conversation even further. So looking forward to having you back here in about an hour's time at 2:30. Thank you, everyone, and have a good lunch. Yeah.
If everyone could just leave from the gate on that side, and please give your names to Vatsal. Thank you.
Hello. Hello. Sure. Hello. Sure.
Hello, hello, hello. Hello, hello.
बाद में और उधर रही क्या ऑडिटोरियम हो गई शायद प्लेन है वहाँ क्या करना है रिकॉर्ड होगा मोस्ट प्रोबेबली होगा रिकॉर्ड होगा तो क्या रिकॉर्ड ये पूछना होगा he has to be recorded quickly. Oh, yeah. You know, I have a PPT. Okay. All right. Could you mail it? Like, have you sent it to anyone? No. I will. Okay, this is a pen drive. Yeah. Can it be? Yes, yes. And I mean, you're worried about it, virus or something? No, 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 not at all. No, no, I'm not worried at all. So I was asking if they have.
I think about it. Get back.
So the play is.
Yeah, I know all of it.
It's not happening.
Yes, yes. Or to, we just have to make that announcement. So to play to. Now. Yeah.
Excuse me, please. Is this the presentation? Yeah. Yeah. We will this. Huh? Sorry? I guess you are the last on the panel. Yeah, yeah. You can just download it on the desktop. Sure, I'm not a DSLR, but you could ask him. If you want to record it in someone's phone, if you want to record it in someone's phone, that can be done. I have a tripod. Yeah. DSLR से record होगा या नहीं? I'm not sure. I'm not sure if that is compatible. I'm not sure if that is compatible with the camera or not. I have a tripod, it's compatible. If you want to do it, hey, people have like iPhones and everything, so you can do a good. System. The play, are they going to speak in the play? उनको कैसे पता चलेगा? Play, like Firefly, that happened inside that thing. So it was audible properly. But how is this thing happening? Stage. Yes, people around? There were a lot of people. Then we can stage. हाँ कोई प्रॉब्लम नहीं होगा. हाँ फिर तो माइक की जरूरत नहीं पड़ी. Five. Not obvious about the
Hi guys, we'll just start the next panel. So if everyone could please settle down. Thank you. So for this panel, we have in the chair our Honorable Vice Chancellor, and he's joined by Professor Anup, Maitri Mishra ma'am, and we have Professor Vijay Raghavan, and of course, Professor Murli. Welcome everyone. We're looking forward to this panel, and we have had a lot of theoretical discussions in the last panel, but hopefully we'll take away some real practice insights from this panel on criminal law clinics. So please settle down. Thank you.
Let me invite you all back to post-lunch, very interesting session. This is about dignity and experiences from criminal law clinics. Clinical legal education, something is a very interesting phenomenon. And clinics, particularly in Indian context, entered into, at least into the pedagogy, very late into the legal education in 1997. But you see the Legal Services Authorities Act, which was responsible for two pioneering works of Justice V.R. Krishnaiah, Justice P.N. Bhagavati. They were the pioneering judges of the Indian Supreme Court, and both were instrumental in institutionalizing National Legal Service Authorities. 1980s, it came almost all later on, after a few years. But the learning from the clinics, particularly the prison clinic, is an amazing experience for law students all over India. Starting from the Delhi University, Professor N.R. Madhavamenon, Professor B.B. Pandey, and several others have followed this. And we have seen learning from the prison clinics, later on juvenile justice clinics, and have not moved further. NALSAR is very fortunate enough. Murli, over more than 8 years, has been offering, 8 years? More than 8 years, he's offering the Prison Legal Services Clinic. And Anup, all of you may be knowing he is our alumni. And along with Preetham is also our alumni. Both batchmates, same batch? Huh? Okay. Oh, Preetham is senior. And we have seen a new clinic emerge in India, first time. When I was teaching criminal law with NLS Bangalore and later on here, we were looking at how do we really work on death penalty lawyering? How do we create a center to understand death penalty litigation and intervene? Time has to come. It took almost 2012, Anup, 2012. Project 39A emerged in India, now moved to NALSAR as a square circle clinic. All the clinics on one side and the Project 39A square circle clinic, the amount of research scholarship engaging which has created in the Supreme Court, all high courts, and all over in India in the legal education is a really rich experience. So I'm grateful that we have wonderful people, all stalwarts, along with Vijay Raghavan, who is known for the criminal justice system, working with the Prayas. Interesting development of the clinical legal education, particularly in criminal law clinics, is new emergence of lawyers and social workers coming together. That's an interesting experiment. And we will hear from all the panelists. I think we will start with Murli, and we will then Vijay, Maitreyi, and Anup. Over to Murli. $15 minutes?
Yeah, 15 minutes.
Yeah.
Okay. What I will do is flag two sets of things for discussion. One is reality from the ground, and then I'll ask certain set of questions about how the question of dignity is handled by the courts, and what are the assumptions that crop up when we observe what is happening in the criminal justice system. First thing is about what are the sides of dignity or indignity that people, especially citizens in conflict with law, experience. I always get this feeling that middle class doesn't know anything about it. At the same time, I also think that the kind of indignities that people in conflict with law experience is also very widely discussed in public fora. The first one is at the beginning, like even before somebody is formally arrested, in the name of search and seizure, how the family members of even the accused are handled is there is a lot of debate whether how far they can go. CRPC talks about it, how police use their high-handedness in dealing with them, and it's not just the accused but the entire family, friends. There are, I mean, as a human rights activist, I can say that in order to arrest the actual accused, there are hundreds of instances where family members are almost put in custody without FIR or anything. This is one site that is always, there's one way of subjecting the family members of the arrest, the accused, to all sorts of indignities is one method that police always resort to as a normal practice, unless the accused is from a middle class or from very powerful social circle. This is this is known to the in everyday practice also it is known. And even when an accused is arrested, now I have done a lot of work, especially on custodial deaths. I must have visited all the police stations in Hyderabad in the past 20 years. I can say that in any casual visitor to a police station, you will see the state of lockups. Like they might be dirty, tainted walls, broken floors, dark cells, and suffocating police custodies. They're all seen as a norm. They're not an exception at all. Even judicial officers, even senior officers also visit them, but they never think that this is not the place of living that an accused deserve. Okay, that has become a norm, and there is a lot of debate about when handcuffs can be used against any person in custody. D.K. Basu talks about it. And they say that it also authorizes you can use the handcuffs as a method of security, but usually it is a method of humiliating. I mean, anybody who walks into the corridors of court also, they will see at least South India is far better. If you go to North India, some 20 people are tied to a same rope as if they are an animal. In front of Nagpur Central Jail, I have seen a lot of times. In front of even Bhagalpur Jail also, I have seen it. So people are tied with a rope, single rope, and they are paraded. So the media watches it, and judiciary also knows about it, because to the same prison, judicial officers also walk in, walk out, but they seem to never object it. Even in the corridors of the courts, when they are produced, just before they are produced into the court, there are no the handcuffs are removed and then produced. Otherwise, it's a very normal, common view for every lawyer, but nobody seems to object to this kind of practice by the state. I have done some 25 interviews about women prisoners. What I found out, especially at the time of entry, more than men, women prisoners are far more seriously humiliated. They are absolutely made naked, if not in front of other prisoners, but as individuals also, in the name of in the name of checking. Similarly, even men, if you, all the students that who visited with me to the prison, Chanchalgoda or Central Prison in Hyderabad, Charlapalli also, they are witness to the scene that 20-30 men prisoners, most of them are made to squat in underwear for 1 hour, 2 hours before they complete the formality of writing, registering their names, father name, and moles and everything. Why do they do? And also in prison conditions, recent judgment on Sukanya Santa, everybody knows how in the prison labor is allocated on the basis of caste. That's not one thing. There are so many other forms of indignities. In the prison barracks, in the same barrack, there will be toilets without doors. At least there is some improvement in the recent past of doors and open air bathing. These are all methods of dealing with prisoners. What exactly these kind of experiences are meant to, or what they are expected to, what effect they do on the prisoner? That is the central question. Fundamentally, when they are handled like this, especially inside the prison, that breaks them down completely, their sense of confidence. They understand the power of the police and the prison, and a kind of, it establishes highly asymmetrical relationship between the minions of criminal justice system and the accused. That is the signal. 25 years back, Maya Daruwala asked me to translate an essay in which how to observe power relations between prison officers and the prisoners. The body language, how they greet each other, how they never use their hands, and quietly they walk. They never look into the eyes of the prison officer. There are hundreds of ways that you can actually see. So in the prison clinic also, when I take the students to the prison, I tell them, please see the body language of the prisoner. You will understand what exactly is happening. Whether prisoners are capable of asserting their right to self-dignity, their rights, can they ask why somebody is treated the way they are being treated? There are separate confinements, and they are not allowed to speak to anybody. These are the different methods now that are used. Especially in Hyderabad, every day around 200 to 300 prisoners visit courts. And for Hyderabad, despite being such a big city, these prisons are supposed to be local courts. Therefore, they are never allowed the lunch allowance. Despite district judges writing to the government saying that the prisoners starve the whole day in the prison. The prisoners are made to wait in the police van the whole day, even without going for a natural call. Okay. So government has not changed the rule that for Hyderabad, the prisons are local, therefore they cannot be given their lunch allowance. Not just, it's just a 60 rupees. So prisoners starve and then go back to prison by evening 5 o'clock or 6 o'clock. By then their lunch is over and then they're supposed to eat only next day morning. These are many methods, and also my lawyers can narrate whole set of stories about prisoners come to the court and they wait the uncertainty whether the court is going to hear their case that day or not. Same is the case. What is the nature of relation between a prisoner and also a lawyer? What is the nature of relationship between public prosecutor and the prisoner? There is a palpable entire subordination. They are almost not citizens at all. They are just subjects. The moment we talk about the reformation and also the moral character of the people in conflict with law, the question of agency completely disappears, which is central for the idea of dignity. The concept of honor completely disappears. So without agency, without honor, there is no question of respecting their dignity, which is foundational for the whole question of rights. So in the entire prison manual, you don't see a single word called right. It is only a privilege. Why they are called privileges? That can be taken away by any time. So there are the whole unwritten code of conduct that really governs the relationship between the minions of the state and the people in conflict with law. And I can use the language of Foucault. It's the technology of power, pattern. It's a messy world. Saying it's a very messy world is much easier. But pattern can also be discernible. There's nothing. It's not very difficult. There is a systematic pattern where the people in conflict with the law never allowed to think that they have an agency. And it is left to the legal representative, their lawyer, to represent all their concerns. Prisoner himself is never allowed to speak up in the court or in the prison. So when there is no question of agency at all, there is no place for the whole idea of concept. So we can ask some fundamental questions. Whoever has read a little bit of Constant Assembly debates know about why the dignity of the individual, securing dignity of the individual precedes before the unity and integrity of the nation. Famous Pattabhiramaya asked this question that it should be reversed. That unity and integrity of the nation should come first and then the dignity of the individual should come later. But Ambedkar firmly stands that without ensuring dignity of the individual, you are not going to build any integrity. I can understand it is about individual rights when it is in conflict with public interest or collective interest. If we apply that framework, even if we accept that all the people who are in conflict with law are the people accused of violating dignity of the other individuals, and there is a conflict between the dignity of the victims of crime, should we not also seriously take interest in the dignity of the victims of the system? If preamble says secure dignity of all the individuals for all citizens, what was the immediate context? The immediate context was the arbitrary nature of the colonial state, against which we have had a 90 years of struggle in the name of nationalism. So the arbitrary and cruel I mean, my friend says that entire colonialism was based on cruelty and loyalty. So, colonialism is one of the sources of indignity. But in 372, we have adopted all the colonial laws as it is. 13 is only an exception. Now, whether there is a transformation of nature of the power from being arbitrary to being democratic, especially in the practice of criminal justice system, is one central question we have to ask. We can talk about any number of concepts which are being used by the higher judiciary, but how to convert all these beautiful concepts into practice at the lower level is one of the fundamental challenges before us. And people, citizens who are in conflict with law, as a class of people, are they excluded from the constitutional vision of ensuring dignity for all the citizens? It almost appears to us that those who are in conflict with the law don't deserve to claim the constitutional vision of dignity. And one question that finally, after listening in the last panel, I had one important doubt. That is, if we understand that human dignity is inherent and also human worth is also inherent, can it also be simultaneously dependent on others? Of course, I agree. I think that if we accept it, that human dignity is inherent and human worth is also inherent, and when you claim that as a right, you also have an obligation to respect the human dignity of other person. But even if we accept all those people who are in conflict with the law needed to be broadly said to be controlled on whatever method, still how to ensure human dignity of the people, their human dignity by the criminal justice system, unless there is already a consensus subjecting people in conflict with law, including convicts, subjecting them series of indignities and humiliations is part of punishment. I don't know whether there is a consensus subjecting people to series of indignities and humiliations is central ingredient of punishment. I don't think we have ever had that kind of consensus. But even without convictions, in the name of pre-trial detentions, a series of humiliations and indignities are hurled at 18 lakh people per year. It's not 1% or 2% who are able to tolerate it, because there seems to be a criminal law common sense which refers to certain kinds of beliefs and certain kinds of practices which are normal, and this is what they deserve. I think this is the context in which I want further discussion on the question of dignity. Thank you.
Thank you, Murli. Murli shared the grassroots realities of how the prison and the police station works. If you wanted to understand, study the criminal justice system, you must visit the prisons and the police stations. And Murli, as a part of the Andhra Pradesh Civil Liberties Committee and the Human Rights Forum, has visited several of the prisons and the police stations. In fact, that was the post-emergency 1980s onwards, the civil liberties movement has emerged all over India, and it's very strong in the Andhra Pradesh. And one of the major activities of the APCLC, all the members, was whenever any information they receive about arrest of a person, immediately they used to visit the police station. That's If you look at the international experience, European Committee of Prevention of Torture, various others came much, much later on. Activism in Andhra Pradesh has clearly demonstrated. Some of us immediately used to visit the police station first. Even now, police station has no access. Nobody has an access. At least some amount of access is provided, or majority access we have in the prisons. Police station, you have no access. So he shared. I'll just leave with one thought. David Biles is a very famous Australian criminologist. Australia is the first country which has established Royal Commission into Aboriginal deaths in custody. What David Biles says is, what happens within the custodial institutions is not open to public scrutiny. That's the major issue. So with this, I'll request Professor Vijay Raghavan to share his views and thoughts.
First of all, thank you to the organizers for inviting me. And it's been a wonderful half day so far. I've really heard some very interesting sessions from all the speakers so far. So I'm going to, time is short, I'm going to quickly jump into what I'm here for. And Murli had told me that when I asked him what should I talk about when we talk about criminal law, legal clinics, and he said, you focus on the issue of indignities, because that's something that comes out very clearly from the work that all of us have been doing. And so I've prepared accordingly. I'm going to speak more about indignities, and maybe towards the end, talk a little bit about what constitutes dignity from a grassroots perspective. So the first question that I framed is like this: who are we talking about? When we as civil society actors, as academicians, as students, faculty from law universities or social work departments, I am located within a social work department of TISS, the Center for Criminology and Justice. And so my perspective may be a little different from what the rest of the people in this hall come from. So we are talking about people, first of all, who do not have family support, or do not have the resources to be able to move the system. If you look at this entire system, you can divide the people who come into the system into these two categories: people who have family support, people who do not have family support. The ones who have family support, their situation is much better. That doesn't mean that the indignities are not being heaped on them, but their situation is better than that without family support. We are talking about people who have very little education or almost non-existent education in the formal education space, and very little knowledge of how the law and the legal systems operate. There is a local versus migrant issue also that one needs to look at, because in cities like Mumbai, there's a very strong sentiment of the local versus the migrant. So the migrant is often seen as somebody who is, creating all the problems. And therefore, right from the justice delivery system people to co-prisoners, they do face various kinds of indignities because of the fact that they are a migrant. We are talking about people who end up as juveniles in prison because of their age being fudged by the police or by a matter of accident. And we are also talking about young people in the age group of 18 to 21. We are talking of people who are arrested in a series of petty offenses, particularly the Indian Railway Act and the Railway Property and Unlawful Possession Act, which are mostly summary trial matters where they are just produced before a judge, and sometimes within a matter of a few couple of remand sessions, they can be convicted. They are in fact actively encouraged to plead guilty, even by the magistrate, that if you plead guilty, you have already spent so much time, so you can be released. When we talk of indignity, I want to bring to the notice of the House this set of offenses which are called summary trial matters. Now, within the same criminal justice system, you have a category of petty offenses where these are summarily tried in the interest of justice. Whereas if you come in for a serious offense, then an entire trial will take place. So these summary trial matters are such where you're produced like ticketless traveling, or a railway crossing, and things of that, where if you do not plead guilty also, you will get a sentence. That's how that system operates. We are also looking at a lot of people with substance abuse problems, and that is also one of the reasons why they end up in crime in many cases. And then there's this category called habitual offenders, which itself, according to me, is a huge indignity, because they are just people with repeat offense backgrounds. And a lot of the times they are repeat offense background people because they keep getting arrested by the police on account of suspicion. So, and then it becomes confirmed that, oh, these are habitual offenders. In the case of women, we are talking of women who have been arrested for the murder of their husbands, or for infanticide cases, or in cases like where they have railway, chain snatching kind of cases, and some women who are arrested for peddling of drugs. We are also talking about women with children, both inside prison and outside prison. So this is the category of people about whom I'm going to talk. Now, let me come straight to how their dignity gets compromised. And I'll walk you through all the three phases: police custody, prison custody, and courts. So the first thing that one needs to look at is the lockup conditions. Deliberately, the lockup conditions are kept dirty, messy, smelly, toilets are not clean, and things of that sort. I'm not even talking about the violence, which is very well known, that takes place in police custody. Then there is the issue of starting from footwear. If you particularly if you come from a poor family background, the first thing that the police does is they ask you to remove your footwear. And you are barefoot, even when you are produced in court, you are barefoot. So that is a signal being given to you. And this is where I'm continuing from where Murli has left off, that the system is trying to give a message. Similarly, if the person says, I want another set of clothes, very often one of the dialogues that the under trial has to hear from the police is, I'll say it in Hindi first and then I'll translate it. Ye tumhare baap ka ghar nahi hai. This is not your father's house, that you can ask for this and that. Okay? So just be happy that we are giving you so much. When it comes to food, there are no clear rules about, like, for example, in prison custody, there's a prison manual. The food has to be given according to certain calories and things of that sort, but no such thing. Often the food is outsourced to a contractor, and he brings some food from a local canteen. That's what they have to eat. Whether meetings with family members will be allowed or not, just no guarantee that they will be allowed. It depends on whether the family can grease the palms of the police to be able to meet the family members. There's a lot of negotiation that takes place at the police station at the point of when the charges are being put on that person. So whether it will be simple hurt or grievous hurt, whether it will be theft or robbery, and this is called in local Mumbai language tod pani, which is basically trying to negotiate with the family that, okay, if you pay so much, then we'll reduce the charges. Under the same category, there's a range of offenses, so we can fix it accordingly. And lawyers, very often there are fixed lawyers. The police and these lawyers have a kind of a deal with each other. So when the family comes and says, we want a lawyer, these lawyers get referred, and these lawyers are people who are basically there to fleece money. In judicial custody, I'm talking of the prison. Again, already Murli has mentioned about strip search. It's a very, very humiliating process. I mean, it could easily be taken care of if body scanners were introduced, or some other way where it could be done in a more dignified way. Allotment of work. Murli has already talked about it, so I'm not going to talk about it. Working for other prisoners. A lot of the times, if you don't have money, you end up working for the other prisoners, like cleaning their clothes or washing their utensils and things of that sort. And in return, you will get some favor. Like, for example, you have the system of buying coupons inside the prison for the prison canteen, where you can buy some additional things than what is being provided to you as part of the prison manual. So a lot of the times the poorer prisoners work for the, the so-called more powerful, richer prisoners. There's a lot of sodomy and sale of sex going on. And here I'm not talking of only, women. I'm talking of also boys, younger boys being used. And sometimes it is because they want something, so they agree to it. People who are arrested on rape and drug addiction or drug peddling charges are treated very badly inside, including by the prison population. They're beaten up and things of that sort. There is a money order economy in the sense that you're allowed to send money, by the family is allowed to send money, but then very few people who don't have money, families, they don't have that money. So then they do a lot of things because they want those coupons, which is even to have cigarettes, you need to buy it from the prison canteen. If there is a round that the superintendent goes every day in the morning to check with everybody if everything is all right, and if, God forbid, anybody makes a complaint, they are treated very well afterwards by the local guards as to why did they complain. So it's again a message being given to the rest of the prison population that don't complain, just be happy with what you have. The question of who gets produced in court, because there is shortage of police escorts. So again, if you have money or if you don't have money, if you have influence, if you don't have influence, these are the parameters based on which it gets decided whether you will be produced in court. And again, during family visits, what is going to be allowed? Sometimes family brings a little bit of food, or they might get clothes, or they might get biscuits and things like that. And again, what will be allowed inside and not allowed inside will depend on, how much you're able to, please the authorities concerned. Yeah, okay. In court, starting from the way in which you're produced in court, very often, of course, handcuffing is not allowed while in court, but what typically happens is that the constable puts their hand behind, so that it doesn't show that they are still handcuffed, and then produced holding the collar in front of the magistrate. And before the person can say something, the next date is announced. So unless you're really gutsy enough to say, I want to say something, my lord, you're not likely to be able to say something. The mulakat that happens in court, a lot of times families prefer to come to court to meet their, relatives in prison, because judicial mulakat, prison mulakat is more difficult. This is easier because if you pay little money to the constable, they'll allow for a mulakat. Again, there are problems there. Not able to talk to their lawyers. A lot of these under trials, they don't know what's going on in their case. Lawyer is there, he's paid money, but they just simply don't know, because the lawyers don't feel that it's their duty to go and talk to them and tell them what's going on in the court. The magistrate, again, very, very uneven picture. You can have magistrates who are very particular about the rights of under trials, and there are those who just don't care. So again, it depends on what kind of a magistrate you're dealing with. And some of the issues that typically get ignored are, for example, the juvenility of the under trial, whether or not he or she is really under 18 or not, a situation of children left outside, health problems that they might be facing, and mental health issues. These are typically the kind of issues that will get neglected when the person is being produced in court, and it is the duty of the magistrate to make sure that these things are being taken care of. And then there is a system we have in our country called jail courts, where prisoners arrested for petty offenses, the matter is tried inside the prison, and it's typically known as Guna Kabul Court. That is, you end up pleading guilty, and whatever time you have spent inside is the set-off sentence that is given to you. I'll just talk of one or two cases. All names have been changed to protect confidentiality. Amrita, she was charged with trafficking of a minor girl. She was in prison for 8 years. Multiple bail applications were rejected. Finally, legal aid was provided through Prayas's efforts in 2019. And during her trial, a critical discrepancy emerged. The name of the original complainant did not match the FIR records. Finally, she was acquitted in 2021. Sheetal's bail. This person was arrested for obstructing a public servant during a fight for parking her bike in a no parking zone. And serious charges were then, including obstructing a government officer to do their duty and assault. Those are the kind of offenses. She was this was COVID lockdown. She was in prison for 2 years because her case papers were misplaced between two jurisdictional courts. Finally, the case was reported in the online platform called The Wire, and then the High Court instituted an inquiry, and then immediately the papers were found within 2 days, and then she was granted bail. There were these two Thai nationals who had come from Thailand. They were arrested under the Passports Act and the Foreigners Act. Actually, they were women who were trafficked to India. They were initially in Rajasthan in sex work, and then one of them got arrested again, and then they got bail also, because she was able to make a claim that her visa is going to get expired, so she needs and on that ground the magistrate had given her bail. These two women then came to Mumbai. They were again arrested under the Passports Act. Long story. Finally, they had to plead guilty to the offense of Passports Act and Foreigners Act, and they were released, and we helped them to go back to Thailand. This is a case of a man who was arrested under the Electricity Act for theft of electricity, and very serious charges were put on him in 2021. His case was mistakenly produced before the magistrate's court, but actually this was a sessions trial matter. We got the matter transferred to the sessions court first. Finally, bail was granted for 25,000. Then a legal aid application was made to reduce the bail amount. And then through the new scheme that the government of India has started, Support to Poor Prisoners scheme, he was released on bail. This is the last one. Dilip was a migrant laborer from West Bengal, was incarcerated since 2018 on charges of kidnapping and ransom. His employer had charged him with these offenses. But according to us, our observation was he was either mentally disturbed or definitely emotionally disturbed. He kept saying that he had taken the child out for a round. Ghumane le gaya tha. But the employer, for some reason, we don't know what is true. He was arrested in all these offenses. We got a lawyer appointed for him. There was no evidence of ransom. And therefore, finally, he pleaded guilty for kidnapping and was sentenced to 5 years of the period that he had already spent inside prison. He's currently working in a shelter home. So just to come to the last point of what I want to say, is you've heard a lot about the indignities that have been heaped upon these people. Now, just a little bit about what brings dignity to the table, again, from the point of view of the grassroots voices. The most important thing that I have found in my entire career of working in this situation is if a person feels heard, he feels that his dignity is restored. And case after case after case, I've heard under trials telling me that ye judge sahab meri baat sunta hai. He hears me out. That's all he wants. He doesn't, he might be a judge. There are two categories of judges from the point of view of, prison population: conviction-oriented judges and those who tend to acquit. So it doesn't really matter to him that, whether he's conviction-oriented or not, but he gives me a hearing. When I want to say something, he listens to me. That's a very important component of dignity. Then the question of individualizing from a general population. When you are able to individualize a situation of a person in a generic situation, it helps in the person feeling dignified. And finally, if you're able to give voice to that person, I think these are some important factors. And I think what we are able to do through our project is that the social workers who work in our project, they try to do these things. They try to bring a voice of the person who's otherwise not heard before the system, and the system does respond. We have also seen judges who are very particular about ensuring that the lawyer has been given, a legal aid lawyer has been given, procedures are being followed, and that really makes a difference when it comes to the last point I want to make. All the social, I was listening to the conversation that happened in the previous session, and it just came to me that some of the non-negotiable social work principles, which is dignity, self-worth, individuality, non-judgmental attitude, empathy, and confidentiality. This is the bedrock of social work practice. And all of this is nothing but bringing dignity to the table. Thank you.
Thank you, Vijay. Vijay brings a lot of grassroots experience of Tata Institute of Social Science and social work professionals, those who have been engaged, and they are attempting to change the judicial discourse, prison discourse, and other criminal justice narratives. I think he has explained through 5 case studies how it works. I think it's very important to understand the indignities of the people. Who are these people? Those who are caught in the web of the criminal justice system, the poor, marginalized, and those who do not have. I think none of them understand what is the law. If you remember 1983, I think Sheila Barse was a pioneering judgment of the Indian Supreme Court. At that time, Justice Bhagavati wrote this judgment. And what he mentioned, I think that started 1983, a precedent. How the criminal justice system has a mandatory duty to educate the people about the law. First time in 1983, Supreme Court said, create a poster in all police stations and prisons. That poster should be, if it is in their language, mother tongue. If it is in Maharashtra, it should be in Marathi. When they are taken to the police station, they will know, if I am arrested, I am entitled to a lawyer, I am entitled to apply for a bail. So all this, in fact, that's a fundamental. How we make them aware about the rights. Of course, there's a legal aid system and other scheme. That's a very interesting. We see D.K. Basu also 1997 mentioning about that, but this is writings only on the wall. Maya Daruwala always mentions that. There's a large number of legal aid awareness, massive awareness which is required. I think that's not possible only with the lawyers, judges. A specialized paralegal, that's what a social worker, lawyer is required. I'll just 2 observations. And Sunil Batra, I think some of you may be aware, is a first case in 1980s where Supreme Court judges visited Tihar prison. Professor B.B. Pandey still narrates, Justice Kailasham, Justice Krishna Iyer, and another judge. First time the judges of the Supreme Court visiting to the prison. Visitorial system is a very effective system where we can see, we can bring the indignities. So I'll stop here. Hearing is very important. Sentencing hearing we have in the court, in the criminal justice system we have realized, but there's a large number. I'll just stop with one because I'm tempted. Andhra Pradesh is the first state in India which introduced technology into the criminal justice system. What we call as a video conferencing system was first time introduced. At that time, some of us, we went to the Andhra Pradesh High Court, challenged it. Why? We know that the permission to visit relatives, permission of the relatives to visit prison is very difficult. But what they can do, they can meet with them, interact with them in the court. If you introduce this technology connecting video conferencing system, absolutely, bahar aake khuli hawa ko, asal forget about even breathing a fresh air coming outside. You know, whenever they come to the court, the relatives will bring food leke aate hai, they will meet them, and the freedom they will have. That's completely. But we could not succeed in challenging in the Andhra Pradesh High Court at that time. I think Inguva Mallikarjuna Sharma was a pioneering. He moved that at that time. So therefore, I think this is a collective exercise. I think he has brought several of the things. I think we should think about creating an awareness, at least some pathway to remove the indignities. I know it's a challenging task. Yeah. Now I'll yeah. Maitreyi, please share your
Hi,
thoughts.
good afternoon, everyone. I'll just sit here and speak. I'm too short for the podium. Okay, so today I want to talk about what my own learnings have been about dignity, but dignity as a felt experience. And these learnings are from the work that we've done previously with Project 39 at NLU Delhi, now here at NALSAR with the Square Circle Clinic on representing death row prisoners. So for the past 10 years, we've represented over 160 prisoners, and this includes both fighting their conviction as well as collecting information and doing sentencing arguments in court as well to reduce the death penalty. Why it's an interesting site to talk about today is because some of the people we have represented are people for whom calls for hanging have been made very publicly. These are people who would have been accused of and sometimes also admitted to raping and murdering a minor or terror offenses and the worst kind of offenses that you potentially hear in the media, in the public. And a conversation that often comes up with us is to people like that, people who have done something so horrible as raping and murdering a 4-year-old, a 3-year-old, do they deserve dignity? And do they deserve the privilege of dignity? Or is dignity the right of only the innocent, whatever you might call innocent, legal or moral? And what I want to talk about specifically today is this exercise that we do called mitigation investigations, which is essentially collecting life stories of individuals who've been sentenced to death so that we can present it in court. It is an exercise which is mandated by law. In 2022, the Supreme Court came up with a judgment, Manoj versus State of Madhya Pradesh, where it mandates a mitigation exercise. It was a case of 3 accused that we were representing, and the court basically says mitigation has to be done. And from 2021, it's regularly been appointing mitigation investigators in these orders and the idea is these mitigation investigators, who are generally social workers or sociologists or anthropologists or psychologists, they'll go into prison. Previously, they couldn't access prisoners. So they'll go into prison, they'll interview these people, they'll interview their families, and they'll put together all of this information and try and argue before or present this information before the court to say why this person shouldn't be sentenced to death. Now, today I will talk about why I think mitigation is a dignity affirming experience. And I think Anup is going to challenge that and talk about why mitigation might be a dignity harming experience eventually. Right. So when I say what I want to talk about is the idea of dignity that emerges when we do these mitigation investigations. And I think we spoke about it as a value, we've spoken about it as a right, as a legal concept, moral concept. What I have learned in all of these years is that it is more like a felt experience. And there is nothing, dignity can neither be given nor taken in that sense, because this is something that the individual experiences. And it is upon them in that sense to experience or allow you to allow themselves to feel indignities or dignities. What I mean by that is that the best that we can do is perhaps create dignity affirming spaces. We can't give dignity because you can't take away dignity. And you can create, and which the criminal justice system does, as Vijay and Murali said, create dignity violating experiences and spaces. And the idea of mitigation why I'm saying is a dignity affirming experience is firstly because of the context in which it takes place. It takes place in a context which is violent, it takes place in a context which is dehumanizing, and it is a stigmatizing criminal justice system. Particularly the fact that, and I think Vijay alluded to this, it is a system that does not hear the individual who it is judging, right? The death row prisoner is never really heard. If you look at how the trial room is structured, the prisoner will be somewhere really far. They can't even hear their own case being argued. They can't often understand what's being argued. And they often don't even interact with the people who are judging them or people who are representing them. In this context, where there is no personhood, there's no recognition of a personhood, there is no validation of a personhood. Mitigation comes as an exercise where you are bearing witness to this person's life. That is the essence of this exercise. Yes, in a formal way, it is information collection. But what you're actually doing is bearing witness to their lives, bearing witness to their lives as they have lived it, bearing witness to their lives as they are living it. And why that is an interesting space to be in is because these lives are being erased, right? These prisoners are not allowed to talk. They're not allowed to tell their stories. So in that sense, they're slowly being erased from the world. But mitigation, the exercise of mitigation, the practice of mitigation, I'm not really talking about the report that we submit or the arguments that we make, but the practice of mitigation, the methodologies adopted, ensure that you are the one listening. They are not the ones listening. You are the one listening. What that includes is sometimes you're listening to their silence, right? If mitigation was an exercise that I had to tell my client, you have to tell me this information at the cost of et cetera, et cetera. If the client had no choice but to tell me that information, I would be suspicious of the fact that mitigation is a dignity affirming exercise. But the point is that it creates a space for negotiation, a negotiation that prisoners have for long forgotten, right? You're negotiating with them constantly, please give me this information. They are not negotiating with you, I will give you this much information, but not that much information. And they are taking space. And in that sense, why I said dignity is a felt experience is because sometimes we go in with assumptions of this person is probably undergoing a really torturous experience as a death row prisoner. And what we find is that the prisoner is trying to resist being labeled as a death row prisoner or being only seen as a death row prisoner, right? They want to be seen as more than just a prisoner. They want to be seen as people. And then we have to look at them as people. So even while they are living in presumably undignified conditions, not presumably, these are undignified conditions, they are still resisting the feeling of indignity by asserting their identity, by asserting who they want to be in front of you, and by making you also negotiate that space with you. You are not, of course, in a certain sense of the word, we are in power, but you are giving up power to them, right? You are letting them take control of a life that for a very long period now has been out of their control. Particularly when it comes to people who might be admitting to the crimes they have committed. Yes, I raped a small girl, I murdered a small person, and what is interesting is that the conversation in those spaces is not one of us either signing off on the crime or us saying it's okay, but da. It is to make them also accept their own guilt sometimes, to come to terms with an act that they have done that for the longest time they have not even come to terms with, because there is so much anger against the system that is treating them so in a way that they don't exist, right? That is the essential project of the criminal justice system sometimes, to erase you from your own life. And I would argue that particularly for people who have done and perpetrated serious offenses, sometimes it can be a doubly dignity affirming space, because here is a space that they are coming to terms with their own shame. They are coming to terms with their own guilt. They are coming to terms with the fact that they may have done something really, really horrible. They may not say it like that. They may say it as questions and they may say it as excuses. But it is so essential to create that space, to co-create that space, because you're not looking for remorse. You're not looking to change them. You're not looking to tell them this is what you should have done, or this is the path to redemption or your redemption. You're just letting them be. And you're accepting them for who they are and not for who they ought to be. That is not the project, right? The project is this is who you are. And in retelling their stories, sometimes they are simultaneously realizing who it is that they are. There might be people who are very kind in certain situations. There might be people who have been extremely violent in other situations. And to come to terms with that and accept that is why I would argue mitigation creates a dignity affirming space, because it allows you to grapple with yourself. It allows you to be dignified in your own eyes in the way that you want to be, not in the way that the system wants you to be, not in the way that your lawyer wants you to be, and not in the way that society thinks you should be. These are complicated narratives, and mitigation is a way to honor those narratives. And the methodologies adopted are then aligned with that, right? The methodology of co-creating space, the methodology of where you both are submitting to that exercise. It's not one person. You are self-disclosing, they are self-disclosing. You are creating then a relationship with them. Yes, it is a professional relationship, but it is an intimate relationship. You are re-establishing intimacies. And I think the felt experience of dignity is all of this, where you can feel intimate without being scared, where you can feel responsible without being shamed, where you can feel terrible but also happy. And I think this, so I would just end at that to say why these are some of the reasons why I think that the exercise of mitigation investigations, that the space that it creates, not necessarily the purpose for what that exercise is mandated, but what it creates and ends up creating is perhaps a byproduct, but then it has adopted a very central, a very, very important project, and that is to make sure that you are creating dignity affirming spaces, because that is all you can do. You can let people feel whatever they want to in a manner that is safe without being judged or without being asked to change what they feel and why they feel that. Thank you.
Thank you, Maitreyi. Yeah, yes. Before Anup comes up, I thought I'll just share a few thoughts of, you have heard the previous two speakers, panelists explaining about arrest, detention, police station, sufferings, agony, and prison. Much more humiliating, frustrating, devastating experience is somebody who is awaiting when the death sentence will be awarded. I think that's what you can't even, the shocking experience is a much more indignity suffering. If we look at 1980s, the rarest of the rare case, Bachan Singh, Supreme Court has come out first time, some rudimentary guidelines, aggravating, mitigating circumstances. But I must appreciate Anup and the team, Project 39A Sphere Circle Clinic. First time Indian Supreme Court started rethinking on this death penalty guidelines, that where mitigation expertise came. And to 2021, that Madhya Pradesh case, and Maitreyi brings in mental health experience. We must understand. Not one day, 1 week, 1 month, years together, prolonged detention. I think then only you will understand what is death penalty victims' agony and suffering. I think that's where I think she mentioned about where she says mitigation is a dignity affirming experience. Anup team started. It's again a very technical legal expertise. I think we need to involve, educate. Thanks to that Supreme Court encouraged. They really heard first time, heard them. And that's where a new precedent started emerging. Thanks, Maitreyi, for bringing this, and Anu. Yeah.
Yeah. Thank you. Thank you, Professor Vasanthi, for having me as a part of this, and thank you, Maitreyi, for setting that up. I'm going to take a different view. Obviously, not that. I mean, whether I believe in it or not is a different issue, but it's something that worries me constantly about this practice of mitigation investigations that we do. The effort to get the Supreme Court to recognize that even though it's said, as Professor Rao was saying, in Bachan Singh, it's nearly 45 years ago, said that, oh, you need to do the rarest of the rare. It's only much later that the court really gets to pay attention to how is this information to be collected. And obviously, there's a strategy that was 6 or 7 years in the making through our cases that led to the Supreme Court in Manoj saying what it did and saying that the defense has a right to present a mitigation investigation report, right? So that's what we do as a defense. We are presenting it as part of the defense. And the court is also calling reports, what it calls independent reports from the jail and the independent psychiatrists, right? So this judgment in Manoj is a 6-7 year long strategy finally coming to fruition in 2021, 2022, right? And of course, it's an interdisciplinary exercise. It's something that Maitreyi and I have written about, the challenges of the interdisciplinary nature of this exercise. It's not something that just lawyers can go and interview and just write up, right? So it's a very complicated exercise, right? And I'm going to be arguing today that there are serious concerns that a mitigation investigation process is a dignity harming experience, right? And why do I say that? We need to understand that a mitigation investigation is essentially an exercise against the clock, right? It's against the clock because the Supreme Court gives you a set number of weeks to go and do this and file a mitigation investigation report, right? And I mean, these are far-flung prisons. The prisons have their own way of how they facilitate this or don't facilitate this and how the barriers they put in place. And the biggest challenge in this exercise is going and gaining the confidence of these individuals, the convicts, in getting them to open up, right? Getting them to speak, because for the longest time, prisoners will want to present very good versions of themselves, right? Or of their families. But what is of tremendous significance in this process is to hear about the worst parts of their life, right? And that's what you need to get to. That's what you need to get people to open up about, right? And you are against a clock. The Supreme Court gives you 8 weeks or 12 weeks or whatever it is. And in that time, you have to gain the confidence and you have to get them to open up and start probing into really dark, disturbing parts of their lives, of their childhood, of their adolescence, of how they were as young adults, if they're married, their married life, their sexual life, domestic abuse, all of those things, right? And in that, and I'm going to be saying that the amount of time we are able to give to genuinely convince them and make them understand why they are doing this, right, is often restricted, right? You're fast forwarding that process because you need to get to the stage of collecting that information, right? Or getting that information, right? And I'm going to, my core of my argument is that the system's commitment to having the death penalty and then presenting this mitigation investigation as somehow an exercise in dignity, because you are then saying, the law is recognizing the need for this mitigation investigation because it's saying, I need to make the sentencing process fair and individualize it. So I am asking you, I'm recognizing it as a right that it as part of the process of making it fairer, of making sentencing fairer. If you want me to really hear about your life story, present this mitigation investigation to me, right? And therefore, confronting the death row prisoner with the choice that if you want your punishment reduced, if you want a shot at your punishment reduced, you have to go through this process. And I think very often this and that presenting of the stakes like that, if you want your punishment reduced, this is what you have to go through, is what then the mitigation investigator is relying on, that they will get the prisoner to open up or at least understand that instrumentally, even though they don't genuinely may or may not want, and there's no way to figure this out, is the problem of this. There is no way you will know whether they genuinely want to have that conversation with you. And that conversation is being had with you for a very, very instrumental reason. And you, as a mitigation investigator who is part of the defense team, is having that because you are playing for it as a matter of strategy. You're playing for it as a matter of criminal defense. You are not playing that strategy as a matter of well-being or for therapeutic reasons, right? You're not doing that. You know that. You're hoping that the other person knows it. But as you get deeper and deeper, and as you go into these aspects, I think often prisoners are forced, not forced, and that's a point. We don't know what their own thinking on is going through these dark, shameful experiences that they have to narrate to more or less an effective stranger within 6 weeks of time, right? And that you don't really have a control over the kind of questions that are being put to you, right? The mitigation investigator is coming and telling you that that person is a part of the defense team, is part of your defense team, and if you want to reduce your punishment, you might want to seriously consider starting to answer these questions and start answering them pretty quickly, right? And of course, it's a very fascinating, complicated dynamic as to, how do you know people are not really telling you the truth? How do you know they're not telling you the full truth? At what point do you introduce contradictions in what they are saying compared to what their family has already told you, right? At what point do you play these strategies in towards getting genuine information that can be presented towards court? So one is, you don't really have, I would think, you don't really have a choice in participating in what are deeply vulnerable conversations, right? And two, you don't have a control over what questions get asked. And thirdly, once this information is collected, right, from the prisoner, from their families, from their acquaintances, from their workplaces, some exercises of this nature will finish probably in 50 hours of interviewing. Some will go on for 400 hours of interviewing. It really depends on a whole host of factors. What you don't control then either is your own story that will be told to the court. So there is one process of collecting all this information, and then there is weaving a narrative about this person that then needs to be presented in court. And of course, senior lawyers who appear for us, they are the biggest hurdle, but I shouldn't be uncharitable towards them. They've been extremely helpful in appearing for us pro bono over the years. But there's also reluctance saying, Arey, why do we want to present all this Rona Dhona in front of the court? Right? And that's a limitation of the legal practitioner to imagine these interdisciplinary ideas of criminal responsibility and culpability and all of. But anyway, the point is, this collection of information then is strongly mediated by court strategy. And the prisoner themselves, the convict themselves, has no real control over what story of theirs is being woven in front of the court, right? Yes, you have the information. What points of that information you emphasize, how you present it, what you emphasize, what you de-emphasize are all matters of legal strategy, right? They are not matters of genuinely telling a story that that person wants you to tell about them in front of 3 Supreme Court judges, right? It is not some sort of pure translation of their story in front of the court, right? So even in that story that gets told about them, they don't really have any control, right? And then I think we are often left feeling and I agree with Maitreyi to that extent, that the narrative of being heard, that their experience of being heard is that repeatedly comes through many of these mitigation investigations. That the number of times we hear that finally I could tell somebody my story is a sentiment that keeps coming through repeatedly. But for me, that is a danger. Because I think very often all of us at work are left wondering if then beyond a point, as you get deeper and deeper into these conversations, there is an emotional dependence that develops, right? That here is this person who's coming day in and day out and coming and talking to you, it's the conversation is being had about your life in a way that nobody ever perhaps has had that conversation, and that dependence, whereas you as a mitigation investigator know you are doing this only for purpose of legal strategy, and the day this is over, you are done. Right? You are done. You are not going to look back, and you have opened certain doors. You have opened certain wounds. You have revisited certain wounds of this person's life in great depth. You have left them confronting questions that they haven't heard articulated to them. You are more or less forcing them to articulate their response to this, right? And very often we hear that, when they go back the next day, they say, okay, you know what, I really was left wondering about all that you asked and all that I said. And it is a deeply disturbing situation to be in when you know you have opened doors you cannot shut, right? You cannot shut it because your job is not to provide that therapeutic process. Your job is to collect that information, strategize it, and put it in front of the court. But by the time you finished your 40 or 50 or 100 hours of interviewing, where have you left that person? Right? And some of you who do the clinic, some of the materials that we will hopefully supply by Monday morning, right? You will see the kind of conversations that are being had, right? And for me, that it raises serious concerns of dignity harms. Because as I said, you're not really sure why they are having this conversation with you, how much of it is forced, how much of it is voluntary, how much of it have they understood that this is for their own good. But even if they understand it is for their own good, the system beyond a point is forcing you to have that conversation, because that is the method that the system has devised for you to even stand a shot at your punishment being reduced from a death sentence to life imprisonment, right? So in that, even you are forced to instrumentalize your own participation, right? In this process, you're forced to participate in that sense, saying, okay, this is the only way you're going to get a reduced punishment, right? So while I have absolutely no doubt that the legal strategy that we played out in the lead up to Manoj has certainly made this administration of death penalty sentencing fairer. It has further individualized it. I think there is a other side to this coin, right? That we have just accepted as collateral risk, right? That we said in a deeply flawed system, this is your best shot at reducing the number of times the Supreme Court confirms the death sentence. And yes, we're extremely proud about how few death sentences. I mean, I just want to, as the court is about to reopen in about a week, I just want to be touch wood, how few death sentences the Supreme Court has been confirming. No death sentence confirmation in the last 2 years, right? It takes a lot of strategizing to get to these places, right? But I often wonder what the human cost of that has been. Thank you.
Just before opening for interactions and questions, this state, Andhra Pradesh state, whether it's a divided or undivided two Telugu states, are also instrumental in starting death penalty abolition movement in India. History has to be written. I think we have to write. First, 1977 Bhumaya Kishtagout. I think finally confirmation was given by Justice Krishna Iyer. Second, 1990s, no? Vishnu Vardhan, 95, Chalapati and Vijayvardhan case. I think one of my friend who passed away, what was his name? He was a lawyer. Chandrasekhar was an amazing, that again went up to, these two are the pioneering cases which came from the Andhra Pradesh state. It's a huge movement for abolition of death penalty, but of course, there is a progressive abolition, very rudimentary, but at least in that context, I would say that mitigation, introducing mitigation expertise is maybe a long pending, but I understand Anoop's point of view. As I said, case law method of teaching we borrowed from American case law is a real storytelling, but this is a devastating storytelling. So I'll stop here. Any questions and answers?
Okay, thank you everyone for their wonderful presentations. I'm Sunesh. I have a brief question. It's triggered mostly by Professor Raghavan's very brief comment there. It is largely about differential treatment amongst prisoners themselves inter se, right? For instance, a substantial chunk of the prison population would believe they're innocent or whatever they have done is justifiable to some extent. But whenever people with, let's say, very heinous or grave crimes, let's say pedophilia, terrorism, etc., do interact with the prison system, all of that discourse they hold to themselves goes out of the picture that they feel justified to treat X individual as much worse than themselves or other peers, right? So how do you locate this differential treatment amongst prisoners or via the prison administration of certain class of prisoners within the dignity discourse? Is it felt that this individual, even though just accused of a UAPA, terrorism, pedophilia offense, is he less worth of dignity than me? Is that the logic?
Okay.
Else can also please add into the.
Yeah. Okay. So, I mean, if I were to do that kind of categorization, I would be going against the grain of my social work training and education, because every individual is the same worth and dignity that we talk about. So we don't definitely do any kind of categorization of that type, but the prison does. So we have access to only certain categories of prisoners. So the particular category that you are talking about, which is people who are arrested in terrorism cases or UAPA or like really serious offenses, we don't have access to those categories. In fact, many of those prisoners are within a very high security ward within the prison, which is known as the Anda barrack, which is an egg-shaped barrack where there are single cells and mostly two people share each cell, or sometimes one person shares each cell. We go into those barracks where they are overflowing, you know, like a barrack which has 75 capacity will have 150 or 200 people in that barrack. So that's our count. But yes, within the prison population itself, as I had already said, there is a hierarchy. And that hierarchy is that people who are arrested in murder offenses think that people who are arrested in theft cases are like really worthless characters, and vice versa, that the person who's arrested for a minor offense says that, okay, I have just stolen some money, but what about this guy? You know, he's killed somebody. So there is that hierarchy which exists. The prison administration also looks at you know, who deserves better treatment in terms of the category of the offense. I don't know if you have answered your question to some extent. Yeah, can add.
Just quickly, even amongst the prisoners, right? Even death row prisoners, for instance, they have that categorization. So like we met a death row prisoner who said that we were talking about like how things change once the death sentence is pronounced by the trial court. And he said, suddenly everybody started looking at me like I was a rapist or a terrorist, right? So even with that, because at the end of the day and the beginning of the day, these are individuals born in and out of society, right? So the social stigma and all of those things continue inside prison as well, amongst death row prisoners. So like we've had a lot of conversations with prisoners who might be accused of, let's say, rape and murder. And if you ask them, should the death sentence exist? They will say, mere liye nahi, but not for me, but for those, maybe somebody who has actually done it, right? So and you have to accept that answer. You can't negotiate that answer with them because you're not there to change their worldview. So yeah, so even within that, it will exist. Yeah.
Just to add one line that there are organizations, for example, who provide legal aid or cash bail, and they have such categorizations that they will not take up a case of a person who's arrested in a case of crimes against women. I've seen many organizations taking that stand.
See, whatever the differences between one set of prisoners to another set of prisoners, but prison population as a whole, when they observe prison officers or police officers being violent and corrupt and all sorts of illegal things, one question they ask is, we don't understand what is this moral high ground you guys are taking against us. You are no different from us completely. So it's not about one prisoner to another prisoner. Of course, they make that kind of difference. When somebody who is accused of rape comes to the prison, he is beaten up by all the prisoners. He is not even protected by those differences are there. But on the whole, they don't lose sight of the nature of the system. So the test is about who are treating them the way they are treated. It's not about who's being treated that way. So it's a test for the system or people who are treating them.
Am I audible?
Yeah, you're audible.
Thank you so much, everyone. That was a very enlightening discussion. My question, I'm Bhavesh from the third year. My question primarily is to Professor Anup and Maitri ma'am. Professor Anup, you made this argument on the perils of mitigation investigation by saying that on one hand, for the death row prisoner, it creates a sense of emotional dependence. Whereas for the council who is involved, it is a strategy, a defense strategy for them, and it's a very instrumental standard of functioning. And basically, after the sentence has been mitigated, the council or the mitigation investigator has no stake involved as such. And basically, you're left with a situation where for the death row prisoner, you have opened some doors that you cannot shut. My question is inspired, actually, it was just going through the India Justice Report fact sheet. And one of the things that was mentioned was that for 5.7 lakh prisoners, 25 psychologists or psychiatrists have been appointed in the country. 25 states or union territories have sanctioned none. So this dearth of facilities for mental health of prisoners, if something is done to seriously work upon this, do you think that this problem that we face of not being able to shut the doors that open up in such sensitive matters, would that be addressed to some extent? And in that way, the judgment in Manoj, could that be enhanced to include this aspect also?
Yeah, thanks for that question. The short answer is no. It will not help. One is that the reason they open up to us is because we are with them. We are on their side, right? We are the defense. The system, and in that sense, prison mental health professionals are not with them. They are seen as people who you have to go to if there is if you are in emergencies. But as a matter of routine, as a chosen interlocutor, they are not the people. The other thing is that the doors that are opened are not, I think often we confuse yes, a lot of emotional dark alleyways come up, and then those are examined, and the fallout from that is serious. I don't think mental health professionals are necessarily the people who need to address that. Because that would be medicalizing and pathologizing it. These are emotional experiences and you have to deal with them. And so what works better and what would work better is peers. If you have a good social support structure within prison, if you have good peer systems within prison, you are likely to be able to deal with those fallouts better. And a lot of our clients have also said that, right? That like Anup alluded to, okay, tonight I couldn't sleep, but after the end of the conversation, because you have sort of tried to close as many doors as possible, by the end of the conversations, they'd be fine. Or they would write to us to say, okay, I spoke to this and this friend and blah, blah, blah. But making it a mental health problem as a pathologizing issue is, to me, a serious concern because then you're just feeding them medicine and that will be numbing them and not, yeah.
Yeah, just a couple more points. I think one is general dearth of supply of mental health professionals, even for the non-prison population itself is a crisis. So you can see how it is worsened much more inside prison. And second, the kind of mental health practices that prison mental health professionals adopt is quite shocking. And, you know, we'd intervened in a case in the Calcutta High Court to look at state of mental health services in West Bengal prisons. You thought these were stuff of the 70s and the 80s. And when Maitreyi and all visited those prisons, it's something to seriously worry about of finding solutions in that direction. Yeah.
Hi, so thank you for all your presentations. My question is to Anup sir and Professor Murli. So, what I've often observed in that judgments in great detail note down and observe the observations made by both of you, how there is an unwritten code of indignities, and in particular facts and scenarios as well, it states how the state has treated them badly. And third thing is that how even in equitable cases, it recognizes that how badly and shortly the investigation was done. I think the recent Justice Mehta judgment acquitting someone which Square Circle working on, it noted that clearly. Now, what Rudul Shah did earlier on was that it bring in constitutional tort. Is that a remedy sufficient enough if the numbers that are given, first of all, numbers are not given, in compensation is not given in most cases, but if it is given on a very high level, can that create a deterring effect? I know funds are not there for basic sustenance, but if such a high bar is made as a deterring effect, you have like 10 crores being imposed or something. So then they might think, you know, let's do a good enough job here only to prevent that 10 crores down the line. Because now they know that they'll not have to face any cost later on. And at the same time, do you believe a special legal regime needs to be established to deal with the officers and the state agents who are being accused of dealing with these crimes? Because right now what happens is like you file an FIR or something, because even in a custodial death case, fake encounter case, they are not even treated as normal criminals. But even if they were to be treated as normal criminals, that would have been a very slow recourse. So considering the power dynamics that were already were inherent in the said in crime, a separate legal regime, could these two things tackle the indignities that have been discussed by both of you and by the other panelists?
Sorry, I should remember your name, but I have forgotten.
Saksham.
Saksham. Yeah. So Saksham, I'd say that often, you know, we make the mistakes, and I think economists are better at it than we are, in terms of when I say we, I mean lawyers. That we think rights declaration on its own will solve problems, right? And we don't worry enough about institutional capacity, institutional design. Once we declare these rights, and so many judgments have said so many wonderful things, but we don't invest enough in thinking about institutional design, right? And institutional capacity. What is the mechanism through which these rights will be realized? So even if you say, yeah, you can, you know, even if the Supreme Court says we are willing to go up to whatever figure you said, 10 crores or whatever, how is it going to get there, right? Who is going to document those things? Who is going to go and argue these things, right? And even if assuming all the legal positions are in place, what often leads to the undoing of those legal positions is a complete lack of institutional design and thought on how we will realize those things. And will, yeah.
See, institutional designing is one thing. Even in case of custodial tortures, the Supreme Court has gone only to the extent of granting the compensation, and we are yet to sign CAT, Convention Against Torture. And in international fora, India is not mincing words at all. It is saying we are a poor country. If we start giving maximum compensation, we will have to empty our exchequer. They're not even mincing the words. And 357 into CRPC, compensation for victims, that has come there. So, forget about making accountable. No police officer is made accountable except in 2 encounter cases in Mumbai. So I think Anup has written very clearly that only giving up to compensation. Beyond that, it is the Supreme Court is not willing to make any police officer accountable for this. So it's very clear. So where is the, and also just day before yesterday Hindu carried is how many custodial deaths? Not even one person, one police officer was convicted. Out of some 5,000 police officers, 70 people were charge sheeted. And people like me have been, see, every year some 4,000 police officers are dismissed from service precisely because of this reason. But they are not made accountable like any other citizen who resort to violence. So this is how you have to read the system's way of handling these questions.
Also, just to add, I think I think it is a fallacy to jump to the solution really quickly. And monetary compensation is never the solution because that's not the problem. The problem lies elsewhere. And I don't think we have a very good grasp of what the problem is of so much violence and so much corruption, all of that. We don't have a grasp of that. We have imagined it and we think compensation will solve something or deter, as you said, but what is actually the problem? Why is this happening? We've not taken enough steps to study the problem, and we have jumped far too quickly to what we think might be the solution. I think that's another problem that we have to sort of refrain from.
If I may just quickly tie it back to the dignity question, I think there's a serious problem, especially in the criminal justice system, of this foundational commitment that every life is of equal value and is inherent worth. And I think many of these criminal justice conversations suffer from a tremendous devaluing of life in our society, right? And therefore it becomes very difficult for some of these conversations to achieve this sense of urgency and criticality that they should, because certain lives are more dispensable than others. And that's the reality of this, right? So from that theoretical position to what we actually see on the ground is that it's okay to lose certain lives over others, right? Yeah. Yeah.
1, 2, 3. Yeah. Mike.
Hi, good evening. This is Ashik, and I'm from the 4th year. Thank you for the wonderful panel. My question stems from the discussions that Professor Murli and Professor Raghavan brought about, very specifically when we were discussing about prisons. So I'm basing my question on the Prisons in India Supreme Court report that came in 2024, which specifically said that a prisoner in Karnataka earns rupees 524 rupees per day for unskilled work, while one in Uttar Pradesh and Telangana earns rupees 25 for the same labor. And I'm just putting this in comparison to the Model Prisons Manual, which came in 2016, which was released by the Ministry of Home Affairs, which said that these rates should be standardized across and a review should happen every 3 years. Now, in Uttar Pradesh, this has not happened in over a decade. And you see significant disparity among states. Now, the question that I stem from this is, how do you see this in the dignity framework?
And secondly, how can we still say that the convict is still not subject to, say, coerced or forced labor, just striking at Article 23? And essentially, how do you reconcile this idea of punishment to economic exploitation at the end of the day?
Not paid equal wages. See, Kerala High Court as well as Gujarat High Court and also Himachal Pradesh High Court in the 80s, very progressive, they gave very progressive judgment saying that once you deprive a person of their personal liberty, and it is your responsibility to create work and also give them food without deducting any amount from their wages. Okay. Supreme Court, in the light of Article 23, said nothing doing. You have to give only not minimum wages. You can't give minimum wages because they don't deserve, because Article 23 says that nothing in this article shall prevent the state from imposing compulsory service for public purpose. And in imposing such service, the state shall not make any discrimination on grounds only of religion, race, caste, and class, and any of them. So in any case, Pondicherry gives much more than Karnataka. So wherever private capital entered and they extract more labor. But if you take that to the way that America is doing, that will go to some other direction where prisoners will be completely exploited. They'll not be paid sufficiently. But here, all the states have no interest in paying even minimum wages. And the Supreme Court also responsible for this situation. So they think that undergoing rigorous imprisonment is a public service. For that, therefore, you can't demand reasonable wages. So that is the situation as of now. People like us are arguing for a long time, but nothing is happening.
I just want to add to what he has said. In that same Supreme Court judgment, it went on to add that the state, number one, shall give minimum wages, but can deduct a reasonable amount for the upkeep of the prisoner, and can also start a victim compensation fund from that wages. I mean, that amounts to double jeopardy. You can't punish the same person twice, for the same offense. So that is the judgment of the Supreme Court, and it has not been challenged after that. So today what's happening is, state by state, they are deciding what should be the kind of wages.
So before Satya Prasoon, there's one, yeah.
Yeah. Hi everyone, I'm Lavish. I'm a third-year law student here. So my question is basically, when we talk about indignities during the criminal justice process, how do we view it beyond that process? Like when we talk about a convict who has completed his sentence, the convict record is still in his image. Like it becomes really difficult for him to find rented places in neighborhoods, to have jobs. Even it becomes difficult to have visa stamps and all sort of that stuff. Like Vijay sir did that thing, he omitted the names within the examples he was giving. So how do you view that within this indignity framework?
Well, there's a lot to be said under that. Firstly, we don't have a department in India, either the state or the central government level, which looks at the issue of rehabilitation. That gives us an indication of how important this issue is. Secondly, if you apply for a government job, there is a column in the form which says, have you ever been arrested or convicted? So the state itself is discriminating on that ground. I had once raised it in a conference when Justice Muralidhar was on the dais, and he said, we'll take it up as a PIL. But I mean, both of us have to actually follow it up with each other. But that is the state of what you're talking about. We don't have any systems of creating any kind of enabling environment for people who come out of prisons. And our work with released prisoners has shown how many problems they face. They get rearrested on suspicion because of past record. They don't get even private outsourcing kind of jobs. Because today, even for a housekeeping job, if you are applying, the employer is asking for a police verification certificate, and that then shows that the person has been arrested, and then he or she is not able to get a job. So it's getting more and more difficult actually. With digitization, the problem is increasing, because now the records are available everywhere.
So it's not just in where prisoners have served their sentence, even in cases of our own acquittals, right? Even in case of our own acquittals, when people are acquitted and released, the Supreme Court, for some odd reason, even if they say, yeah, this person is innocent and shouldn't have been, is very, very reluctant to give any compensation, right? So very often they have spent years on death row, years on incarcerated, and when they're released on acquittal, they often feel that their lives were better back inside prison, right? Their lives are destroyed. They have no capacity. They have no social networks to reintegrate into society, right? There's nobody around to help them, right? So in that sense, the complete lack of responsibility from the state. So all this talk of, the purpose of punishment is rehabilitation and reintegration, all good on paper, but as Vijay's own extensive experience and work on rehabilitation has shown, very little, walking the talk on this, right? Yeah.
And sir, even I saw this recent.
Yeah.
Yeah, just see, even when a candidate is acquitted, the Supreme Court in a case actually upheld dismissal of that person from the job, saying that civil liability is completely different from criminal liability. And this is the narrowest interpretation of right against a double jeopardy. No person should be punished twice. This is even acquittal here. There is no conviction also. Still, I think in the Oxford Handbook on Constitutional Law, there is this extensive discussion on this case also.
Yeah. Yeah, Himanshu Satyaprashu. Yeah. Himanshu.
Yeah, so this one is to Maitreyi and Anu. Basically, this whole, there are two questions here, two brief questions from the paradigm of ethics of care, basically, I'm trying to probe it. One of the concerns which you put was that the strategic approach and the lawyering approach and the straitjacket kind of a deadline approach towards mitigating meetings somehow compromise or undermine the underlying care ethics of that whole enterprise and the dignity aspect. But my counter to that would be, wouldn't that be a case by case or a particular context specific kind of a scenario of the ethics of care, in the sense that if we take the analogy of the firefighters, because that is the kind of case that you're dealing with, matters of last resort, wouldn't in those kinds of situations of methods of last resort, the very idea of care would have baked in this whole idea of strategizing and rescuing and those aspects of care? So that is one question to you, that wouldn't the kind of work that you are dealing with require you per se, that your care ethics must be baking in this whole idea of strategizing? And the second question is on this whole, which is slightly more philosophical in a sense, on this whole question of are they better off or worse off after this experience? And one of the panelists seems to suggest that they are better off after this experience, and you seem to be suggesting they are worse off. And again, by a matter of analogy, I'm saying this, that on questions of intimate relationships of any kind, right? Would it be better off to have gone through that experience with the knowledge that you're going to ultimately, break apart and divorce and all, or should it be that you should have never gone through that experience at all? It's a first principles based question, right? So, and my position on that would be, it is always better, because again, as a realist, to have gone through that experience and have experienced that at least in bits and pieces also, than to have never gone through that kind of an experience. So these are the two.
I think my view on that question, Anshuman, thanks for that, is that the system's commitment to have the death penalty, right? And then its subsequent efforts to make the death penalty fairer and fairer, because you are saying, okay, I'm going to have the death penalty come what may. Now we can walk around this boundary that I have set for you and try and make it fairer and fairer. It is because of that you're exposing individuals to this kind of vulnerability and risk. So for me, it is the exposure and risk that the system creates for individuals in these situations. Of course, we are left with no choice but to do the best we can, and that's baked into the practice, right? Of how we do it, what are the doors we try to close. All of that is baked in because of a certain kind of helplessness and the commitment that the system has to saying, okay, we are going to operate within the death penalty. Now, within this, let's figure it out. And for me, that's the fundamental problem of exposure to risk.
So yes, so the ethics of care is baked into both the legal strategy, but also the process of mitigation, as I was explaining. And I think where I might agree with Anup on the larger point of that it creates harm is because what you're telling me is that I need to tell my most intimate story so that the system can feel better about itself, right? So it's not even really for me, it's for the system. And I think that's where the annoyance of a lot of our clients comes from. That why is this important? They might like it is, yeah. I think a lot of the clients see through the fact that you are trying to make yourself feel better, and you are exposing me to all of this thing. On the reason why I do think it's better to have gone through this experience if it's done well is because both it's like a, and you can see it sometimes from day 1 to day 20 or 30 or sometimes for the day 400. You can see a dawning of a recognition of your own self, because it's not again, I think, and the key is that it's not about making you better, it's not about making you redeem yourself, it's about making you engage with yourself, and I think that is what makes it a much I think a valuable exercise in and of itself.
I thank all the panelists for their insightful interventions. My question is to Professor Anup. I'm taking off from something that you said towards the end, that the state sees some lives as more dispensable. I'm asking this question normatively, that should we not see some classes of individuals as more dispensable? And I'm asking this that does heaping of societal indignity and stigmatization a universal moral wrong? And I'm asking, framing this question in context of a class of individuals, convicts, especially pedophiles and war criminals. And if there are legislations which allow for a pedophile convict that their name is publicly available in a register, and the same thing is with respect to war criminals. So do you think that indignity is something where societal indignity is something which is justified in some cases, or can be justified in some cases? In these cases of, say, pedophiles, I'm taking two extreme examples, and war criminals, where one would say that these are not victims of structural injustice, but these were choices that were made on attacking these certain people. And are there any case laws that looks at the issue of stigmatization and uh, and indignity in context of these classes of convicts? Thank you.
So Satya, thanks for that very thought-provoking question. I don't think I'm making an argument that there shouldn't be differential punishment based that there shouldn't be differential punishment based on what kind of offense we're talking about. I'm okay with that position, saying that different offenses require different kinds of punishment. I also don't view necessarily all punishments as being indignity in that sense, of as being violative of dignity. That is also not my position, that all punishments in criminal law are violative of dignity. But I do think then that if there is a certain inherent worth of certain individuals, there are certain kinds of treatments we cannot be subjecting people to. And that's the framework within which I'm looking at it. In that context, I think I do not agree with the sex offenders registry, right? Because I believe perpetual punishment is an indignity. And I think a sex offenders registry is perpetual punishment. And that I don't believe in. That's a concept I don't believe in, that somebody can be in perpetuity punished for something that they have done. I'm okay with proportionate punishment. I'm okay with differential punishment. All of that I don't view within the framework of indignity, but perpetual punishment, that somehow there are a class of acts beyond which there is no escape for the rest of your life, is something I don't, yeah.
That there are enough studies in the West to show how it is impacting the families and children of people where sex offender registries have been created. So you're then creating another class of people who are not responsible for that behavior, their children and their families who are really going through a lot of harassment. They are not getting jobs. Their children are finding it difficult in school. They are being socially stigmatized. So there is a lot of material on that.
We'll take the last question from my colleague in the prison clinic. Yes.
Thank you for the wonderful session, sir. My name is Archana. I work as a fair legal advocate. Mostly I deal with CCLs, child conflicting in law. So my question is, the rehabilitations of juvenile delinquents is been null because they again fall into the adult prison. So the dignity, as sir have shared, it is a hearing them, individualism and voice. Once they are addressed in observation home itself, then we can avoid the further troubling of the creating an anti-social elements. So why we are not focusing on the observation in the bottom level itself? Why we are not working on the dignity in juvenile homes? My concern on that.
One is Prayas is also working in the observation home, one of our units. But there are many other organizations working only on children in conflict with law. But the number is less. I completely agree with you that most of the organizations are working, and that is true of adults as well. Most of the work that is happening in prisons is only inside the prison. The post-release work in India is very, very neglected, whether it is children or whether it is adults. So that's what we've just recently come across a case in Mumbai region of a juvenile who has been in prison since 2018. And we are now in 2025. He was a juvenile when the crime was committed. So that is really an issue that constantly needs to be looked in.
Thanks, Murli, Vijay, Maitreyi, and Anup. It was an extremely enriching discussions. Thanks. I think let's stop here. Maybe, yeah.
Thank you, everyone. I thank our Vice Chancellor, sir, for sharing this wonderful session. At 5 o'clock, we have a wonderful theatre performance at the auditorium by the First Drop Theatre called Echoing Justice. I kindly request you all to take your tea and make your way to the auditorium.